second appeal. Second appeal. Are mentioning is it off? Is it off? Is it off? It off. Yes.
May I permit it? One restoration application, ma'am.
Restoration application of
8 madam.
second appeal.
No, no, 2 days.
Monday.
May I have
Someone mentioning on Monday. Yes.
mention a matter, my lord, called correction of an order passed by my
Come on Monday. Monday. All mentioning on Monday.
The to mention a matter, Your Lordship, just to take these two matters under the head of to be mentioned, these are all notification matters, Your Lordship.
Monday, then come on Monday. I will take up these matters. Yes, call the list. 170. Please take down. This matter appears under the heading of to be mentioned. Second within bracket second appeal. None appears on behalf of the petitioner. It appears from the report of the department that paper books are ready. Let the matter go out to the list. Parties are liberty to mention. Next. Papers.
Appellant. In this matter, my lord,
You are for the appellant.
appellant, my lord, and as per instruction I have got from the bar, my lord, Mr. Basudev Bagh, who is appearing on behalf of the respondents, my lord, he died, my lord. Therefore, administrative notice should be issued. And otherwise, my lord, appeal is ready for the hearing, and your lordship may fix.
Paper books are ready.
Yes, yes, my lord. Paper book is ready.
LCR has received.
Yes.
It is found to be in order and incomplete.
As it is very old matter, my lord, therefore, in paper book, my lord, it has been written.
Mr. Basudev Bagh,
he is appearing on behalf of the respondent.
on behalf of the respondent. He received one copy of paper book also.
Paper book also. He died, my lord. As per instruction, my lord, from the bar I have got that he died. Therefore, my lord, one administrative notice should be issued upon the respondents.
Learned counsel appearing on behalf of the appellant submits that Mr. Basudev Bagh, learned advocate, represented the respondent in this second appeal. She submits that Mr. Bagh has expired.
Expired during pandemic, my lord, as I have heard, my lord.
So she need C6 necessary order from this court so that the administrative notice be served upon the respondent. Or the learned counsel peruse the record and the papers. It appears from the report that in the year in the year 2018, Mr. Vasudev Bagh has received one copy of paper book from the department. Considering the submission on behalf of the appellant, department is directed to serve administrative notice upon the respondents and place a report with this court on the returnable date. Let the matter appear in the list on second week of January 2025.
Lord, kindly fix up a date, my lord, returnable date.
The department is directed to carry out the instruction
Second week of January.
promptly. Next.
Lordship, I appear on behalf of the respondent. Is appearing for extension of interim orders. Lordship will find from the last order, 30th September 2024. My lord, order of status quo is continued till the 29th of November 2024.
The matter was mentioned before your lordship. It is returnable on the 6th of December. Upon the mentioning being allowed at our end, kindly also consider that there is an order dated 30th of September, wherein the learned court had asked the appellants to give us the relevant papers. This is a very old matter, and we have obtained the Vakalatnama in a very peculiar circumstances, hearing which this honorable court had allowed us to submit our Vakalatnama. We have written letters to them, but we have not been served with a copy of the paper book.
The difficulty is, my lord, this is a change brief for my instructing advocates also. Lordship sees this is an old matter from 1976. So, my lord, we have also applied for certified copies and have not yet obtained the same. Whatever documents are available with us, we can make over, but my lord, perhaps reconstruction will be required in this.
Kindly appreciates without the paper book.
No, paper book is not ready.
I do not have a paper book, a copy of the paper book.
Problem is change brief for both sets of advocates. So, my lord, nobody has the complete records.
Paper book. Your lordship directs the department to let us take a Xerox copy
Appeal of
the paper book.
1997.
Lordship,
Yes, your lordship.
1997.
Without your lordship's directions, we cannot also access the judicial paper books. If your lordship gives a direction, we can make copies of the same and circulate among
That
ourselves.
direction will be beneficial.
Such a poor papers. Yes, noting. LCR has reached. Paper book. One paper book is there. LCR has reached. Paper books is on the record. Everything is there.
We do not have a copy without your lordship's direction.
To receive the copy.
Without
not
your
received
lordship's
the copy.
direction,
Both
without
of
your,
you are new, I think.
yes, both
There
of
are ready paper books are there with the department.
Kindly
What-
allow
what?
inspected it.
To inspect the document.
kindly
Paper book with the record, one paper book is here.
we have
Other 5 copy must have there.
lordship, we have tried our best to get it from the department, but until and unless your lordship provides an order to that effect, the department will not allow us to access the
My lord,
paper
we have
books
also applied for certified copies. This is
Of
not
what?
or the paper books. But
Certified copy of paper book.
certified
You are
copy.
the appellant.
I am for the
Bunch of documents, my lord.
No. Everything will be there. There are LCR has reached.
The direction.
LCR has reached, paper books are ready, and both of you are saying that we have not received the paper book. You are new now in the on behalf of the appellant.
Lordship, at the
Take the necessary action, my lord. Lordship will kindly extend the interim order for the time being.
kindly let me apprise your lordship of
Only
the facts and
extending the
circumstances.
interim order would not suffice. I have to dispose of the appeal. The whole appeals
Kindly-
are there.
kindly
You know
extend
the
at your lordship.
load of this court.
Yes, we appreciate that, my lord. Lordship, my lord, fix it at your lordship's convenience.
Subject to being corrected, lordship had already
So
fixed it on
you
6th of
are
December.
representing all the parties.
Respondents.
You are respondents, you are appellants. All the respondents.
Yes.
Very well.
So there's a sole respondent.
I will allow both of you to inspect the record
Please. Most
and receive the paper book, if any, in the record. Okay, please take down. This matter appears under the heading of to be mentioned. Learned counsel for the appellant submits that the interim order passed by this court is going to expire on 29th of November 2024. আজকে তো 29 expiring today করে expiring today. So he paid for necessary order for extension of interim order. Heard the learned counsel for the appellant as well as the respondent. Considering the submissions, comma, the interim order passed by this court on the earlier occasion is further extended till 23rd of December 2024 or until further order, whichever is earlier. Let the matter appear in the list on 20th of December 2024 under the heading of hearing. Full stop. Next para. It has been submitted by the learned counsels for the parties that they may be allowed to inspect the papers of the instant second appeal. Learned counsel for the respondent also argued that he has not received the paper book. Considering the situation, the learned counsel for the learned counsel on record for the parties are at leave to inspect the record in the department. In turn, the department shall provide necessary paper book in necessary copy of paper book in favor of the parties, in favor of the councils. Come on, 20th.
Wait for
Great first. Actually,
Next.
Great.
Matter will have appearing for today. Ultimately, matter has been settled. Client don't want to proceed with the matter. Both the appellants are present before your lordship, my lord, and this is the written instruction.
So what you want?
Non-prosecution.
Non-prosecution. Non-prosecution means
Non-prosecution
The-
of the appeal.
the decree under appeal would be affirmed. That will be sufficient, or you want any application under order 23 like that? Not necessary.
But what are the terms conditions they have not stated? They have only given
Very
the
well, very. So it is the instruction on behalf of the appellant.
appellants, and both the appellants are present before your lordship, my lord.
পেয়ে যাবেন এটা নিয়ে
It is the judgment of reversal, my lord.
Okay, Narayan Chandra Rai was the plaintiff.
Yes.
After his demise,
Uh,
Muhammad Roy and Pintu Roy are the now appellant here. Please take down. You are appearing on behalf of the respondent.
No,
No, my lord.
Both are
she is the
Okay,
advocate.
okay. Hmm. learned advocate on record on behalf of appellant submits that the matter was settled outside the court. Thus, the appellants are not intending to proceed further with this second appeal. Accordingly, the appellants has handed over. Can you provide me a date?
Date in instruction order. একটু ওটা জশাবের থেকে ফেরত দিন না ডেটটা
বিশ্বনাথ
একবার এটা একটু দিন
দাও ওটা দাও।
আজকে ডেটটা দেখুন
কি বললাম? Has handed over a written instruction of the appellant. Full stop. Both the appellants are personally present before this court. Let the written instruction of the appellant be taken on record. Full stop. Next paragraph. Considering the submissions of the parties and considering the contents of the written instruction, comma, the instant second appeal be and the same is hereby dismissed as not pressed. Full stop. Next paragraph. Decree under appeal is hereby affirmed. Stop. Next paragraph. Interim order, if any, passed by this court during the pendency of the instant second appeal be hereby also vacated. Stop. Next paragraph.
ম্যাডাম only thing মানে
LCR, if received, be sent down immediately to the office, to the learned trial court. Can you use the
স্পেশাল মেসেঞ্জার ফার্স্ট
special messenger? Okay. কি বলবো? To the learned trial court through a special messenger. Semicolon. Cost to be borne by the appellants. Full stop. Appellants is directed to submit the special messenger cost within a fortnight. On such submission, the department shall engage a special messenger so that the LCR be sent down immediately. Full stop. Next paragraph. The next paragraph. The parties are at leave to receive back the original documents placed in the record by submission of certified copies thereof according to the law. SAT disposed of.
grateful. A certificate copy of photocopy মানে because there are some your lordship has mentioned certificate copy, therefore it may be certificate copy of photocopy.
Certified copy of the exhibited document has to be produced for return of the
Yes, yes,
original
that-
exhibit. That is the order.
Grateful.
Next.
My lord, I am for the appellant, my lord. But I am praying for not press. My lord, my client instructed me for written instructed me for not press, my lord, kindly.
Your Lordship, may kindly see the last order once. Why they are not prosecuting? The signature of the second appellant and the third appellant was forged. The third appellant has died also. On the last occasion, Your Lordship, some mistake went in the order. The allegation has been recorded that the signature has been forged by the erstwhile advocate on record. It should be the appellant number 1, Your Lordship. Now, when the affidavit has been called for, they want to withdraw this. Your Lordship, my client had affirmed an affidavit, but unfortunately, it is on green. He has sent it on this, so it could not be filed. Your
What
Lordship,
is the issue here? I cannot
because
recollect.
Your Lordship, the first appellant had filed this appeal. He forged the signature of the second appellant and the third appellant and filed it. When my client, the second appellant, found out about this, he had approached the advocate on record who had filed this case. He withdrew from the brief. The third appellant has died. And my learned friend is carrying an instruction, I do not know from whom, to withdraw this. This is only from the first appellant. He has got the instruction. Who has forged the signatures?
Let me find out the memo of appeal first.
Your Lordship. Your Lordship may see the wakalatnama.
Second appeal. Memo. Appellants are Satyanaran, Niranjan, and Srimati Leela
So,
Chakraborty.
Your Lordship, Niranjan Chakravarti is my client and Leela Chakravarti has died.
So you are also one of the appellants.
I have been made one of the appellants. I never filed this appeal.
What is this going on?
Your Lordship, there is a FIR also pending in Behrampur. My learned friend's client is out on bail in that for forging this signature.
Very well. Then a specific proceeding has been initiated.
Your Lordship.
So why in this appeal?
Now, Your Lordship may consider only my concern would be, Your Lordship, in the last order, it has been recorded that it has been forged by the erstwhile advocate on record. That will be very unfortunate for that advocate because I'm sure he would not have forged it. The appellant number 1 has forged it. So it should not stay on record that the advocate forged it.
So what is the stage of the appeal? The
Lordship,
LCR has received 7 copies, 7 files of LCR has received. Paper books are not ready.
Your Lordship, I have been served with the
Court of
paper.
Behrampur, Murshidabad. Yes,
Your Lordship, I have the paper book.
you have received the paper book.
I have received from that erstwhile advocate only.
So what do you want now? Both of you.
Your Lordship, I only want
My-
correction of this.
My lord, for not place, my lord, this is my transfer brief, my lord. Previous.
How you cannot press the appeal is pending by 3 appellants and you have signed the instruction by 1 appellant. Whatever may be the signature right or not, I do not know. But only 1 appellant has signed the instruction. How can it be taken?
Then my lord,
And you are appearing on behalf of rest too.
No, Your Lordship, only respondent number, appellant number 2 because the third has died.
Third has died.
It's
So
recorded
now-
in the earlier order also.
Now how can it be
brother,
done?
my lord, own brother, my lord.
No, step brothers, not own brothers.
Whatever may be, they are relatives. They know each other.
Yes, Your Lordship.
So
The third
they
one is the
must have
sister.
known about their death.
Yes, Your Lordship, it's recorded submission from the first appellant only.
So this peculiar situation is arises.
Your Lordship.
What about the notice of appeal? Whether it is served upon the respondent?
Because Your Lordship, the state is the respondent. I was not prosecuting, so
So
my learned
you are, have you filed any can like that?
No, Your Lordship.
So why the cans are pending?
Because Your Lordship, the can is from them only. I think one of them is for the substitution. I have not filed any can.
You have not filed any can. So
All are by my learned friends.
you have appeared on behalf of respondent number 2.
Appellant number 2,
Appellant number 2, Nilanjan Chakraborty.
Niranjan Chakravarti.
Niranjan Chakraborty.
Your Lordship.
Niranjan Chakraborty,
Lordship.
you have appeared.
Your Lordship.
And you are submitting that this appeal was not filed by you. Very well. And what about Leela Chakraborty? Expired.
Yes, and my client says that her signature also would have been forged, but I cannot get into it, but she has expired. That's why my learned friend wants to now withdraw it.
So what is your submission?
Your Lordship may only see the last order where
I have
that
seen the order. What is your submission?
My instruction is only not place, my lord, this matter. my
You
lord.
are advocate on record in
My
this
lord.
matter. So when Leela Chakraborty died,
My learned friends have, I think I have the date.
can you file the death certificate? Notice of appeal has been served.
Your Lordship, she died on 6th of June 2023, but I don't have the death certificate. My client lives in Bombay. My learned
Have you
friends-
filed the Vakalatnama?
Your Lordship, I have.
When died? June 2023.
Yes, Your Lordship. 6th June 2023.
Okay, please take down. What is your name?
Pavitra Vishwas.
Learned counsel. Pavitra Vishwas, learned counsel appearing on behalf of the appellant. Submits that.
Appellant number 1.
The appellant submits that. Appellant number 1. Appellant number 1 submits that. His client doesn't want to proceed further with this matter. Learned counsel appears on behalf of
Appellant number 2,
appellant number 2. Your name?
Varun Kedia.
Varun Kedia submits that the instant appeal was preferred by 3 appellants, but his client, that is appellant number 2, has not signed the Vakalatnama at the time of filing the instant appeal. He further submits that the appellant number 3 has expired on 6th of June 2023. He further submits that this situation was demonstrated before this court, wherein this court has noted that the signature appearing on Vakalatnama by the appellant number 2 has been forged by learned advocate on record, has been forged by erstwhile learned advocate on record. He submits that the appellant number 1 must have forged the document, not the advocate on record. Let the submission of the Mr. Kedia be taken on record. Full stop. Next para. A peculiar situation arises in this matter. It has been alleged that the appeal was filed only by appellant number 1, naming other 2 appellants and allegedly forging the signature of other 2 appellants in the Vakalatnama. Are you ready to proceed with this appeal?
Your Lordship, that instruction I'll have to take. Your Lordship may give a date just for taking that
I
instruction.
cannot give
Because
a
Your
date.
Lordship, it was not mentioned upon notice. I could not even ask my client. He doesn't live here.
No, you have appeared in this appeal.
But Your Lordship, that time it was not for non-prosecution. I had prayed that I be arrayed as a respondent. But if my learned friend doesn't want to pursue the appeal, there is no point arraying me as a respondent in this.
No, you are the appellant.
No, I am not the appellant. I had not filed.
You
And
have,
I do not
now-
intend to pursue it as an appellant for sure. But
So
Your
then
Lordship, it's
what
better.
is your instruction?
Your Lordship, it's better that it is on record because of this peculiar nature. It should be on record that my client doesn't want to pursue it. I don't want to make that submission. Lordship, otherwise it will come on me next day.
Automatically the appeal has already been abated.
Your Lordship.
Okay. That would be the ultimate order.
If your lordship records that order, it's I cannot stand in the way.
automatically abated. Already
Your lordship,
legal already abatement is there.
abatement is there.
Take down. কি বললাম বলো last time? In the vocal now. Full stop. Considering the entire situation. No. Appellant number 1 has handed over. Learned advocate on record. For the appellant number 1 has handed over a written instruction. Let the written instruction be taken on record. Considering the entire situation, it appears to me that the instant appeal has already been abated by the death of the respondent number, appellant number 3. Who expired on 6th of June 2023. Considering the situation, the instant appeal beyond the same is hereby abated. No further order. Next.
Number 123.
Defendant and appellant before in the first appellate court is the appellant before your lordship. The parties have arrived at a conclusion to settle, mitigate the litigation. But they required to file an application for compromise. Kindly pass an order, one-line order to that effect that they are directed to file an application. But the respondent.
You are appearing on behalf of the respondent.
The appellant here.
Appellant.
Defendant, appellant. Defendant in the suit, appellant in the first appellate court, now the appellant. I lost both the courts.
Okay.
They were present and they were supposed to be present. Mr. Bosak was there.
Okay. Learned counsel appearing on behalf of the appellant submits that the matter has been settled outside the court between the parties. They are intending to prefer a specific application before this court. He seeks some accommodation. Full stop. Concerning the submission of the appellant, the matter be adjourned today. List the matter January
As your lordship.
January
My
10th.
lord, if you suits your lordship, kindly fix end of before the vacation or any day before the vacation.
Any day before the vacation means 20th.
Month.
20th December. Another same heading correct. Next.
124. Well, 124 and 25, my lord, during the pendency of the appeal, some of the appellants have expired. I have
Okay.
to take out an application for.
You are the appellant.
I am the appellant.
125, 124.
24 and
Learned counsel appearing on behalf of the appellant submits that during the pendency of the appeal, some of the appellant has expired. So he required to take appropriate steps in this appeal. Full stop. He seeks some accommodation. According the matter be adjourned today, list the matter on 20th,
My lord, same. Kindly, same.
20th December.
Correct.
Yes. Next.
126.
Lord, 126. I am for respondent number 2 and 3. My lord, I have not been served any.
Rajdeep Bhattaji appearing for the appellant, my lord, he is engaged in other court. Kindly pass it over for file, my lord. Kindly pass it over.
Yes. What is your submission? Today is for hearing appeal.
No, I think, this is a substitution application is pending.
Okay.
That application we have received
Okay, application.
and other papers we have not received.
Okay, let it be pass it over.
He's coming.
Okay. Next.
For the respondents in this matter, this is the appeal of 2000, my lord. Thereafter, the appellants did not turn up. Even the respondent number 1 has died. We don't know whether they have filed any substitution application or not. No paper book, nothing has been communicated to us.
So why it is appearing under the heading of application?
Perhaps some applications is pending, but no copy has been served upon us.
Who mentioned this matter? Upon mentioning these matters are listed under the heading of application. Some application must have been pending.
We have mentioned this matter, but it is appeal of 2000.
You have mentioned this matter.
They are not my lord, interested to move it, and their appeal is pending for a long time.
Who is for the appellant? Land counsel? Do you know?
Mr. Ranjan Chatterjee.
Mr. Ranjan Chatterjee.
I have tried to contact it, but did not get any other details. Only the bar association number has mentioned. My clerk went there and tried to find him out.
Otherwise, I have to serve an administrative notice.
Lordship. It will be better, my lord, your lordship, direct the department to serve a notice upon the appellants.
An application is pending for prosecution for sending prosecution under section 340 CRPC against you.
But no copy has been served upon us.
These are the old applications. You have forged some documents.
As per my knowledge, nothing has been forged. And no, there is no suppression of evidence also. Initially, the suit was decreed in their favor, challenging that we preferred an appeal. Appeal was decided in our favor.
Now you have filed affidavit in opposition against that application. You have used affidavit. Have you any knowledge?
No, well, it's a transfer brief.
Are you representing all the respondents?
Respondent number 2 and 3. One has died. Jiten Mondol and Nabokanta Mondol.
What is your name?
And Shobhan Das Gupta, the advocate on record, who filed a no objection vokalatnama on behalf of the respondents.
Mr. Indrajit Mondol and Mr.
They are initially appearing.
Amit
Thereafter,
Banerjee learned counsels appeared on behalf of the respondent number 1, 2, and 3. Now you are representing. Okay, please take down. The instant appeal is pending since 2000, since the year 2000. After substitution, no, after death of respondent number 1, his heirs are substituted. Notices were served upon the substituted respondent. Your name is?
Shobhan Mojumdar.
So, learned counsel Shobhan Mojumdar appears on behalf of the
Respondent number 2 and 3.
respondent number 2 and 3. Full stop. Next, this matter appears under the heading of to be mentioned. Full stop. It was mentioned by the respondent that this matter is pending since long without any further proceeding of the instant appeal. Have you served notice after mentioning?
No, because there is nobody. My clerk is going there in the bar number, trying to find out the learned advocate who is representing the appellant, but could not trace him out.
Okay. Learned counsel for the respondent submits that he could not serve notice upon the appellant before mentioned. Considering the situation and considering the fact that the appellant is not turning up. Appellant is not turning up to proceed with this appeal. I think it necessary to fix a specific date for the appearance of the appellant. Let the matter be appear in the list on 13th of December under the same heading for passing appropriate order. In the meantime, the respondent is directed to serve the notice upon the learned counsel on record on behalf of the appellant, informing the fact that the matter shall appear in the list on the adjourned date. Next.
Twenty-eight, my lord. I am appealing the appellant. Ask me Eviction to serve copy of the section 5 application upon all the respondents, substituted respondents. And that has not been done yet. And my lord, for accommodation. In the meantime, I will serve all the substituted respondents.
Learned counsel for the appellant submits that he could not serve the application for continuation of delay upon the all respondents. He seeks accommodation. According the matter be adjourned today, list the matter be adjourned today. Let the matter go out of the list. After service upon the respondent, the appellant is at liberty to mention.
Well, can it be kept on kept in
No,
the
no,
list,
no.
my lord? Because
You
once
will-
it got
To
out
complete
of
the service, thereafter you will mention. Next.
129.
129, my lord. I am appealing, my lord, on behalf of the respondents. Now, my lord,
Who is
My-
for the appellant?
my lord,
You are for the appellant.
now, my lord, this application, my lord, I have taken out an application being can number 7. Now, my lord, this application's main purpose is, my lord, to get the appeal heard out. My lord, suit for eviction on the ground of reasonable requirement, my lord, decreed in 2003,
Application for expeditious disposal of the
the
appeal.
appeal.
Very well. Yes.
And, my lord,
What is the stage of the appeal?
yes,
Paper books ready?
paper, my lord, say in second appeal, paper book contains 2 courts judgment and, my lord, the order of admission. Now, my lord, the problem here lies is, my lord, in 2004, at the time of admission of the appeal, my lord, there was a direction to call for the LCR. Now, my lord, what I find, my junior, my lord, on checking up of the records,
Yeah.
I find, my lord, in the department, the LCR is not tagged. My lord, I could not find a lay note or, my lord, in the record saying that the LCR has been received, examined, found to be correct. Now, my lord, I am the landlord, my lord, my requirement, my lord, 2004, it is in a position in a stalemate condition. Now, my lord, this is one thing. Second, from the record I find, my lord, there was a substitution taken place at the behest of the appellant on the death of the sole appellant. Now, my lord, by an order, my lord, kindly takes up, I don't know, my lord, can 7 is tagged with the record or not. Now, my lord, appellant number 1 was substituted by appellant number 1A to 1E. But
Okay.
also, my lord, in the record, my lord, I do not find that substitution has been carried out. So, my lord, today I am unaware of the number of appellants. To me, as on there, my lord, to my file, there is only sole appellant. But from the record, the register administration has recorded that a substitution has taken effect.
Yes. Substitution taken place.
Yes, my lord, by an order dated 21st of June 2023.
Yes.
Now, my lord, thereafter, this has to be corrected, my lord, in the paper books which is lying in the department, my lord. My lord, supposedly, my lord, that amendment has not taken effect. The memo appeal is still lying in the name of sole appellant.
So what is your purpose now? Why do you
Now-
want to submit?
Now, my lord, only thing, my lord, the LCR, my lord, if to be tagged with the, my lord, second appeal, otherwise, my lord, the appeal could not be heard out.
Let me hear it out. Appeal. Second appeal, they are tracing. They have not traced the record, LCR. The
My lord, it's
department
not
has
tagged
noted.
with the, my lord, otherwise the direction was the LCR to be tagged with the record. But today, when the file has been brought, LCR is not there. So, my lord, it is not tagged with the record.
So what is your submission now?
My lord, kindly directs the department to tag the LCR with the record.
Once you want to expeditious disposal,
Yes.
and again you want that the appeal
My lord,
be delayed.
this formality, my lord, my prayer is
No,
for
in the second appeal,
yes.
it is not always required to see the LCR.
But
There
it's
are
upon the
substantial
appellant.
question of law.
If he
Yes.
waives, if he
Let
waives,
him start. Let him start. It is not always required to peruse the LCR.
very well.
There are substantial question of law. I can be assumed the law in the first appellate order and the first order of the decree. This is the only way. You can start it.
ঠিক আছে। আপনাকে জিজ্ঞেস করছি তো।
But today is not the lordship application for hearing application.
Yes, I am disposing the application. When you want to start? Next week? Yes?
Immediately after the opening.
Immediately after reopening means two
Record করা
months.
করতে
No,
পারবেন?
December. After December, January.
First week of January, your lordship will-
First week of January means 3rd of January.
আর কিছু And Lord, in the meantime, your lordship direct to carry out the amendment in the first title and also tag the trial court. That's why, Lord,
That's why I will look after, no issue. When you want to ready to proceed with this appeal, this is only the question.
Lord, it is necessary.
It has already been amended. You have not.
Then, Lord,
Then
I'm
why are you arguing on that point? I have already heard.
I have not seen, Lord, my guardian
Yes.
says that.
No, it has already been amended.
Then,
Their
Lord,
names are already appearing in the memo of the appeal.
Lordship,
Everything is there.
fix the date in the month of January, early part of January, and Lord, in the meantime, direct the department to tag the record.
What is the number of can? Can 7.
Can 7 of 2024.
Please take down. Can 7 কোথায়?
আমি appeal করি for all the respondents. না,
লিস্টে আসছে
রেসপন্ডেন্ট
ক্যান না থাকলে লিস্টে দেবেন না কেন? দেখছেন কেন? বুঝতে পারলেন হয় নাকি? এইভাবে হয়? ক্যান না থেকে আমি ক্যান অর্ডার করবো কি করে? Give me a copy of can. ক্যান ছাড়া নেবেন না রেকর্ড। ক্যান থাকলে নেবেন, না হলে নেবেন না। Can 7 of 2024. This is an application for appropriate order filed by the respondent. Learned counsel appearing on behalf of the respondent submits that the instant can application was filed for expeditious disposal of the instant appeal. The original can application is not placed on the record. A copy of the can application is received. Let it be kept on the record. Received from the learned counsel for the appellant. Let it be kept on the record. Full stop. It appears that the appeal is otherwise ready for hearing. Accordingly, I think it necessary to pass an appropriate order in respect of Can 7 2024. Under the above observation, Can 7 of 2024 is disposed of with the direction that the instant appeal is to be heard out as early as possible. Full stop. Let the can be taken up for hearing at the time of hearing of the appeal. Along with the hearing of the appeal. Along with the hearing of the appeal. Let the matter be fixed for hearing on January 3rd, 2024. Full stop. In the meantime, 2025. In the meantime, the department is directed to place the LCR along with this record.
The can number 7 is kept alive.
Kept alive, and it will be disposed of along with the appeal.
So if affidavit of service we kept on record.
Okay. Affidavit of service is kept. Next.
Almost senior.
This matter, I am appearing for the plaintiff appellant petitioner.
But I am for the respondent, my lord.
For declaration of title and recovery of possession by the for encroachment by the defendant number 1. That suit was defeated by the trial court. Defendant number 1 is about to appeal. In the appeal, their title has not been accepted by the court, but court said our title there is some defect, there is no partition. And in the appeal,
Order of reversal.
Against that, we find this appeal. It is admitted on the ground. So the application for injunction.
But after 12 years, my lord,
Yes.
they are praying for injunction.
No, why it is appearing under the heading of application? Is there any application pending?
Yes, we have filed this application for injunction.
What is the can number?
Can 3 of 2024.
ঠিক কোথায়? Affidavit of service. Okay. Can 3.
Can see.
Yes.
Paragraph 10 you also come application.
Yes.
But it's difficult to have to come with the document. Photograph annex.
Yes.
Well, I am the owner and possessor of the property which is demarcated in the application. My lord, kindly see one photograph has been annexed before your lordship. That is purely my property. But as per my learned friend's argument, some portion has been encroached by myself. That has been indicated in the copy of the decree, and thereafter it has been reversed in my favor. They have challenged the same thing. But it is a pure subject matter of length of hearing. I am doing my business. I am aged person. I am doing my business in that premises. Nothing is new. Injunction is not required. My lord, kindly direct my learned friend to prepare the paper book. We will come back after 1 month.
The appeal of 2013. Paper
Yes.
book is ready, I think.
No,
Whether
paper
paper
book is
book
not
is
ready.
ready.
They have not taken any direction of paper book, my lord. It is not paper book ready. It not supplied to me. My lord, kindly give. Very well, my lord. Give me 7 days time. I will come back.
Whether you want to use affidavit in opposition against this application, or this application is an injunction application, it has to be heard first.
My lord, if your lordship kindly fix the matter for hearing, my lord, entire matter should be heard.
Today is the date fixed for hearing.
My lord, for hearing of entire matter and hearing of the appeal, my lord.
No, no.
That can be disposed of.
Application is fixed today. What is your submission today?
My lord, now opposing, I want to use ability.
That's why I'm asking you. What you want to do today?
My lord.
Next week?
My lord, give me 2 weeks, my lord. My lord, I am doing my business, my lord. That should not be disturbed. Yes.
Today, status quo and they file.
My lord, after 12 years, they will create a disturbance.
Paragraph 10.
After 12 years, they are saying all these things. At the time of final hearing, my lord, they are saying paper book is ready, my lord. At this juncture, my lord, application can be granted of injunction, my lord. Never, my lord. I am opposed, my lord. I oppose. Kindly fix the matter for hearing, my lord. Any date, my lord.
And it will be next day, that is would be 6th. 6th of December.
My lord. For final hearing.
Can 3 of 2024. This is an application for injunction filed by the appellant. It is the contention of the affidavit of service filed on behalf of the petition is taken on record. Learned counsel for the appellant submits that the respondent stroke opposite party intends to going to change the respondent opposite party and his main and agents has started change the nature and character of the suit property. He submits for the purpose of disposal of the instant appeal, the nature and character of the suit property be maintained by an order of injunction. Full stop. Learned counsel for the respondent seeks accommodation to file affidavit in opposition against the application. Let the matter be fixed on 6th of December under the same head, under the same heading. under the heading of hearing of injunction order. Another same heading, another same heading, full stop. In the meantime, the respondent is directed to receive the paper books from the department. Department is directed to place the LCR with this record on the adjourned date. Come on, 6th.
Being for an identity order, status as on today. Even.
After 12 years. Come on 6th, come on 6th. I'll pass the order on that date.
On 6th, your lordship is going to get the penalty.
I have fixed the order under the same heading, that is heading of hearing application.
Also direct call for
They have called for LCR, and as because I have to go through the injunction order, so I have to assess the record, otherwise it is not possible.
I am ready to hear what the hearing of that.
Very well.
For the injunction.
Very well.
Yes, my case.
Very well. Next.
I am for the respondent number 1, Amin Sheikh. Not pardon me, my lord. Not my brief has been misplaced, my lord. Not kindly fix.
So why it is appearing under the heading of application? What application?
My
What
lord,
application?
kindly
Stay
fix-
application. Stay of what? Injunction order. Have you served the copy of application upon the respondent?
Yes. No, kindly fix the date, my lord. In the meantime, I will collect.
Record has not come till today, lordship. Direction was passed in the year 2016. Till today, the work record has not come. As per knowledge of my.
No,
I'm sorry to interrupt, my lord, the Eviction service may be given.
What affidavit? In which matter?
One.
This matter?
Sorry, one that is just earlier matter.
Affidavit of service is already taken on record.
জানি না
State of status quo of the Honorable High Court. Opposite party constructed major construction violating the order of the Honorable Court. I issued a notice to officer in charge that they took no step. Then I prepared a representation before the Superintendent of Police of Murshidabad.
Is there any order of injunction?
Lordship.
Where is the order?
On 7/11/2016, order dated. Passed by the Honorable Justice Jyotimay Bhattacharya and Ishan Chandra Das. Amin Sheikh and Mohan Sheikh constructed the construction.
What is the CAN 7363?
This is a injunction application.
Injunction application. It is pending.
Lordship.
You are the appellant here.
Lordship.
Your appeal was not admitted by the learned trial court, by the first appellate court. Application under section 5 has been turned down. You have preferred appeal against that order.
is going on?
The trial court record was sent to the learned additional district session judge first court, Jangipur, Murshidabad, for correction.
Title should
Title suit 24 of 2010. Incorrect copy of appeal of certified copy has been prepared. Filed the appeal. Nothing is there. It was not reached.
But we at page number 2, all for record was issued by the Honorable Justice Injunction. And record has not come till today.
Order dated?
Order dated 7/11/2016. Further direction needed, Lordship, for bring the lower court record.
So in this situation, what can be done?
Lordship, further direction needed for bring the lower court record. Unless lower court record come before the honorable court, hearing cannot be proceed, Lordship. Also, there may be a paper book direction. They are violating the injunction order, Lordship. Huge construction made by the Amin Sheikh and Mohammed Sheikh at the shoot property, violating the honorable order of the honorable High Court.
You don't have the prima facie in this matter. You have lost in the first appeal, in the decree. You have dismissed the suit. They have dismissed the suit. Your appeal is time barred. Now you are in second appeal has got an order of injunction. Stay, actually, you have received an order of status quo. I do not know what is the status there in the nature of the suit property. I want to peruse the decree. There is no such decree. Decree is sent to the lower court. This is the situation. Further, however, you have received the all applications.
Respondent number 1, Amin Sheikh.
No, you have received the application. Application means application for injunction,
Not served.
notice of appeal. You have not served upon that.
Lordship. It is a change with Lordship.
So the application,
Is
that is
not
the
served.
can was not served.
Not served.
How can we proceed today?
Kindly fix the date of hearing of the injunction application.
In the meantime, you serve.
I shall serve all the parties.
You are only representing respondent number 1.
Amin Sheikh.
There are other respondents also. Okay, please take down. It is reported by the department that the copy of decree of trial court was sent down for necessary correction to the court of law and additional district and session judge. First court, Jangipur, Murshidabad. The corrected copies of decree was not received. Department is directed to issue the reminder to the trial court so that the corrected decree may reach to this court on or before 13th of December 2024. Next para. Today is fixed for hearing an application being can 1 of 2016 within bracket old can 7363 of 2016. Full stop. Copy of the can application was not served upon the respondent. Full stop. The petitioner stroke appellant is directed to serve the copy of application upon all the respondents and file an affidavit of service on the returnable date. Let the matter appear in the list on 20th. Next, the department is directed to take appropriate steps according to the direction of this court.
Matter will appear, Lordship.
20th.
Another same heading.
28 December.
20th December. Next,
March of
132, I am for the appellant, madam. The learned advocate on record, madam, could not come to court due to his father illness, madam.
very well. Not
Madam,
today.
Yes, madam.
It will appear next Friday.
Madam, I have been instructed, madam, in the meantime, serve the copy of these applications and all the rest.
What applications?
I have been instructed one section 5 and one restoration. Matter has been dismissed for default.
Okay.
Sub notice of these all the respondents.
Please take down. Learned counsel appearing on behalf of the appellant submits that there are some medical emergency in the house of the learned advocate on record for the appellant. Accordingly, the matter cannot be taken up today. No, accordingly, he seeks some accommodation. Considering the submission, the matter be adjourned today. Full stop. The appellant is directed. Now, let the matter appear in the list on 6th of December.
Malat kindly
13th.
20th.
No, 13th. 13th of December. 13th of December on the same heading. In the meantime, the appellant is directed to serve the applications upon the all respondents and file an affidavit of service on the adjourned date.
Great. Great.
Next.
I think
133 fixed on 13th December. Call 134.
Lord, in item number 134, my lord, Mr. Shukanto Chakravarti is stepping for the respondent number 2, my lord. His legs are before court number 11, my lord.
Mr. Bandyopadhyay is arguing in this matter?
Yes.
Yes, but so far as the factual aspects I have already
Yes.
considered, I want to cite the judgment.
Yes.
Let,
You can proceed.
yes,
You can
lord. Yes,
You just take notes.
yes.
that we had probably submitted the deed of family settlement. I'm just inquiring whether it is there in the record, then I can supply another.
I have seen the family settlement on the earlier occasion.
Yes, my lord, I just want
It must be there.
not there, my lord, then we can supply another.
This is the deed of family settlement, wherein
Yes, the
second floor, dotala, like that dispute is there. In Bengali term, there are some disputes.
But if it is not there, my lord, we will supply another.
No, no, you have supplied it already.
I probably I have a copy.
এই ডকুমেন্ট কোথায় দাও?
I will supply another one.
Where is it? আর কিছু নেই এটা? আরো কাগজ ছিল তো, কোথায় যাইব? হ্যাঁ, কোথায় রেখে দাও?
It was subletting.
Yes.
Probably recollect. My lord, I had taken a point that since my lord, the appellant was inducted by a person, my lord, who is no more, and the suit was filed by his legal heir, and his title can be, my lord, denied by the, my lord, tenant, and is not stopped by section 160. My lord, that I made the submission, my lord. Now, in support of that, my lord, I want to cite one judgment. I'll not multiply, I'll just cite one judgment.
Yes.
But this is 1990, volume 1, SCC. Have I said? Well, probably I
No, last of all, you have submitted R.K. Gupta was staying in the suit property as a family member of the tenant. This is your submission.
Yes. Well, I had
Now, only question was raised whether being a tenant, can you challenge the title of the plaintiff appellant,
plaintiff,
landlord?
well, I had relied on that family settlement, and I had shown from their admission that it was already there from 1969.
And you have also shown some evidences.
Evidence that admittedly he claimed to be the owner when he was not the owner of the premises.
Yes.
Now, in support of that, but because of 116, this is estoppel, I say that this is not applicable since not he claimed the right as a legal heir of the original landlord.
Okay.
It's a derivative type, title. হ্যাঁ বলছি দেখাইনি এখন 116 will not stand in the way.
Yes. Give me the judgment.
1990, volume 1, SCC, page 252. Subhash Chandra's case. So paragraph 7.
Yes.
Yeah, it is true, but has it actually got the paragraph 7?
Yes.
It's true that the doctrine of estoppel ordinarily applies where the tenant has been let into possession by the plaintiff, where the landlord has not himself inducted the tenant in the disputed property and his rights are founded on a derivative title. For example, as an assignee, donee, vendee, heirs, etc. The position is that position is a little different. A tenant already in possession can challenge the plaintiff's claim of derivative title showing that real owner is somebody else. But this is subject to the rule enunciated by section 116 of the evidence. The section does not permit the tenant during the continuance of tenancy to deny that his landlord had at the beginning of the tenancy a title to the property. The rule is not confined in its applications to cases where the original landlord brings an action for eviction. A transferee from such landlord also can claim the benefit, but that will be limited to, and here it is not transferee, it is legal here. The question of title of the original landlord, the time when the tenant was let in. So far as the claim of
এই দেখো দেখো পড়ে গেল কি কারো লাগলো নাকি দেখো রাখো রাখো yes
হ্যাঁ and এটা তো এখন চেঞ্জ হয়ে গেছে না so far the claim of having derived a good title from the original landlord is concerned, the same does not come under the protection of the doctrine of estoppel and is vulnerable to a challenge. The tenant is entitled to show that the plaintiff has not, as a matter of fact, secured a transfer from the original landlord, or that the alleged transfer is ineffective for some other valid reason, which renders the transfer to be non-existent in the eye of law. My lord, I can. This is the principles, my lord, set by the Honorable Supreme. The 116 did not come into my way. I can go to the facts also, if you so. In that case, there was transfer of the suit property.
okay
Now, if you are to smaller, this is so far as the family settlement, with ownership, and his claim as landlord, so far as that portion is concerned. Now, the issue, on which the second appeal was admitted, that questions your lordship had shown with your lordship.
1 and 5
Two questions. One
two
is
substantial question 1 and 5
1 and 5.
issue number 1 and 5
Now, yes, may I just again page 117 of this bunch, was quoted, my lord. I have also given the order. The order referred 1 and 5 only. Now 177, my lord, paragraph 6, bottom.
177,
my lord. 177.
Yes.
For that, in the absence of any finding that the appellant parted with exclusive positions in favor of the alleged subtenant, or that the tenant had not retained any control in respect of the suit premises, the Court of Appeal below erred in law in holding that the arrangement made by the tenant enabling her brother-in-law to reside in the suit premises amounts to subletting.
Yes.
Then, page 178, then 5, for that the Court of Appeal below erred in law in holding that there was subletting in the absence of any finding that any consideration passed from the alleged subtenant to the appellant. Now, you also have already gone through the judgments of the trial court and the appellate court. But
Yes.
I can just again, my lord, if you see one small.
No, you proceed. I know.
Yes. Now, there was no finding that any considerations was paid. There was no finding that, in fact, my lord, this Gupta, R.K. Gupta.
R.K. Gupta.
R.K. Gupta was not there from the beginning of the tenancy, and he was inducted when the defendant my lord, left the premises. After leaving the premises, my lord, R.K. Gupta was allowed to use the rented portion. There is no such findings. In fact, on the contrary, my lord, it was the evidence of my lord, the DW1, which says that they, because of the paucity of the accommodations, my lord, they had another accommodations. And when they hired the another accommodations, at that time, this R.K. Gupta, because they are all family members. These are the all along the case of the defendant number 1. And that was also recorded. Now, to constitute a subletting, my lord, it requires some, my lord, some evidence of consideration being parted with. Either direct or even circumstantial evidence. There should be something. My lord, I'll be, my lord, it is in fact Wharton's pocket law dictionary, but it was, my lord, ultimately revised by Justice Krishna Iyer and then again revised by Dr. Justice A.R. Lakshmanan. Lord, I'll just show the definition, the meaning of subletting. You know. Want, my lord, I can produce the book also. The subletting means transfer of an exclusive right to enjoy the property in favor of third party, and the said right must be in lieu of payment of some compensation or rent.
Yes.
My lord, Your Lordship will not find from my lord, either from the judgment of the trial court or from the judgment of the lower appellate court that there was any such findings, my lord, that any compensation has been paid or some type of rent is being paid.
Yes.
Now, so far as the subletting where the family members are involved, my lord, I'll cite only 3 judgments. My lord, the first judgment I'll be.
Is there any definition of family member in the Transfer of Property Act?
I'll have to check, my lord. I'll have to check.
What is the status of family in the Transfer of Property Act?
Family, there was joint family concept, because they are not Bengali.
No, in transfer in West Bengal Premises Tenancy Act, there are some judgments.
In the West
The
Bengal
family
premises,
members, everything.
only the persons
Persons
the legal
residing
heir,
along with the tenant are the family members.
Yes.
In the Premises Tenancy Act, there is clear.
There is
There is some judgment
of the tenant.
Yes.
Because of the
For
definition of the tenant.
Yes. But
I'll show, my lord, on this issue, I'll show it. But first, I'll be relying on the Calcutta High Court judgment, my lord, reported at 1977 to CLJ. Page 153. 153. I'll be referring to, my lord, paragraph 14 of that judgment, my lord.
yes. This is West Bengal Premises Tenancy Act.
This is also, my lord, under the old act. The present case, this was also under the old act.
Under the Premises Tenancy Act. Page, paragraph 14.
Paragraph 14. Kindly take from paragraph 13, my lord. May I read from 13?
Yes.
It was then submitted by Mr. Shokyan Mukherjee that when in the instances the defense of joint tenancy was put forward and such defense has not been duly proved by the legal evidence, then the presumptions under section 13(1)(a) would be that the tenant had really sublet the premises. In support of such contentions, he relied on such and such judgment. A decision of the Allahabad High Court, wherein a suit for evictions of a tenant on the ground of subletting, the tenant had set up a positive case of partnership. Such defense was found by the tribunal as not have been established. As a result thereof, it has been observed that under section 14(4) of the Delhi Rent Control Act, the tribunal was bound to give effect to the legal presumption that the tenant had really sublet the premises. Lastly, in addition to his submissions on the jurisdiction of this court to interfere in the appeal, in the facts and circumstances as indicated above, it was submitted by Mr. Mukherjee that subletting having been duly found up to this court, once the defendant would not be permitted to raise any question against such determination or take any defense contrary thereto. In support of his contention, Mr. Mukherjee relied on determinations in the cases of such and such. In that case, the ejectment notice was held to be valid and sufficient by the High Court and a previous judgment between the parties. Then came the later special bench decisions in the case of such and such. On the determination whereof it was found that the notice in question was not valid and sufficient for the purpose of section 13(6) of the 1956 Act. And as such, it was contended, relying on the said special bench decision, that since the defect in the notice would go to the root of court jurisdiction, and as such, notwithstanding the previous judgment affirming the validity and sufficiency of the notice, the appellant would be entitled to take the point about the defect in the notice and to argue on that. But it has been observed that after the previous decision of the High Court affirming the validity and sufficiency of the ejectment notice, it would not be open to the appellant to raise the point over again. Then, but it is true that the fact subletting which has been found as aforesaid and up to this court cannot be re-agitated. Thus, the question would be that in terms of the demand order, whether the plaintiff on the evidence as adduced has been established, has able to establish subletting by defendant number 1 in favor of defendant number 2 after the commencement of the act. On evidence, it appears that the defendant number 1 has left the said premises permanently in 1962 on constructing his own house, and the defendant number 2 is living in the said premises since 1943. Defendant number 1 left in 1962 and defendant number 2 was living in the premises 1943. Here, R.K. Gupta has not been made party. The case of the defendant is one of joint tenancy, and there is evidence that on some occasions the defendant number 2 has tendered the rent for payment to the plaintiff. Although rent receipts were issued in the name of the defendant number 1, the fact that the defendant number 1 has left the said premises in 1962 and since then or even prior to that defendant number was living would not itself prove the fact of subletting or commencement thereof after the incorporation of 1956 Act.
Yes.
You also will find from the evidence that there was no evidence that R.K. Gupta came only after this defendant number 1, Draupadi Gupta, left the premises. On the other hand, it is not contradicted even by the plaintiff that R.K. Gupta was there in the tenanted premises.
No, here is the fact is that there is a joint tenancy.
No, there is no joint tenancy. The tenancy receipts were issued in the name of defendant number 1 only. The fact was that sometimes defendant number 2 tendered.
Yes.
But here, it was always tendered by defendant number 1. But this is the fact that the defendant number 2 was also residing in the said premises since 1943.
Okay. Yes.
Next judgment, my lord, another Calcutta High Court judgment, my lord, this is a 89 CWN. Page 447. এটা দিতে হবে। নন্দলাল চৌধুরী ভলিউম এখানে 89 CW তখন তো ভলিউম 89টাই তো ভলিউম 89 CWN page 447 নন্দলাল চৌধুরী versus Monica Bhatt. Now kindly take para 7 last portions. My lord, your lordships can read the entire, but that will not be relevant for my case. My lord, that is why, my lord, I will be referring the last portion. The principles has been enunciated. That is why, my lord, I want to show. My lord, kindly take page 451.
Yes.
It may, my lord, may be cited by them also. My lord, I will be reading from middle of the page. I find, has your lordship got it after 15 line.
Start.
I find that ordinarily it is not possible.
I find that only it is not possible. Got it.
Because I had cited my lord, the meaning of, my lord, subletting from the dictionary. Then what the I find that ordinarily it is not possible for the plaintiff landlord to prove by direct evidence that the passing of consideration between the tenant and the third person for granting exclusive possessions of the premises to the latter. In the absence of direct or cogent evidence from either of party for deciding the question of the court has to consider the surrounding circumstances to draw proper inference. My lord, I submitted on the last when I showed that if there is no direct inference, but there should be some circumstances indicated in the evidence or in the pleading that there is that one can at least presume that there was passing of considerations or there was payment of rent. That something should be there. But in my case, that something was absolutely absent. Then, my lord, where a tenant defendant transferred exclusive possessions of the whole or part of the suit premises to a person who is not a member of the defendant's family for a considerable period, and the reasons of such transfer has not been satisfactorily explained as in the present case. But I'm pausing here again for a moment. To a person who is not a member of the family. Now the family, my lord, in joint family concept, my lord, I can produce the dictionary meaning of the family also. It includes the persons who decide that he is the son of brother-in-law or brother-in-law. My lord,
He is the brother-in-law.
Brother-in-law. So he was absolutely, my lord, in a joint family, he is the family. Now, has not been satisfactorily explained, the only proper inference that can be drawn is that defendant sublet the suit premises to the third person, who is Shambhu. So the exception is who is not a member of the defendant's family. In that case, Shambhu was not a member of defendant's family. But there was no direct evidence of payment of considerations or payment of rent. The first portion I cited that there should be something on the basis of which one can presume that there was passing of considerations. Something, there should be something. Here, this is not evident. The third judgment I will be citing, this is 1992, volume 2, SCC 331. এটা আমার কাছে কপি আছে সবকটার কাছে কপি নেই গিয়েছি Paragraphs 5 and 6 मतलब ये तो 2005 থেকে May I read? Mala, these are short judgment.
Yes, proceed.
The appellant is the tenant of premises consisting of 3 rooms, a kitchen, and a toilet situated at Jaipur. The respondent filed a suit for eviction of the appellant on the ground of reasonable and bona fide personal necessity and subletting of the premises. Mala, here there is no ground of reasonable bona without his consent. The said suit was decreed by the trial court on both the grounds. On appeal, the suit was dismissed by the additional district judge. The High Court in second appeal reversed the judgment and decreed the additional district and decree of the additional district judge and has passed a decree for eviction against the appellant on the ground that the appellant has sublet or otherwise parted with possessions of the premises without the consent of the landlord. Then 3. In the site plan, the premises which have been let to the appellant are marked as K. The adjacent room marked as J has been let out by the respondent to Sri Mohendra Singh, the father-in-law of the appellant. Kindly, the one room.
Yes.
And the another room was let out to the brother-in-law. And he is residing there. And the additional district judge has found that the Mohendra Singh is employed by the appellant and is residing in the room marked J as a tenant under the respondent. It has been found that he has been using the latrine and kitchen which form part of the premises let out to the appellant. Mohendra Singh, being the brother-in-law of the appellant and in the service of the appellant, could not be taken to be a subtenant merely by the use of kitchen and latrine, and that for subtenancy it is essential that the possession of the Mohendra Singh upon the premises must be exclusive. It was also found that the exclusive possession was not proved by the evidence of the respondent and much less any proof of rent being paid to the appellant. The High Court in the second appeal has reversed the said findings and the additional decision rely upon the evidence of Mohendra Singh, who has admitted that the premises marked K1 to K4 are utilized by him, and Vishnu Dev DW3, who has stated in cross-examination that the appellant is not in occupation of the premises. Portion marked K1 to K has been occupied by Mohendra Singh. The High Court has held that the appellant has sublet or otherwise parted with the premises without the permission of the landlord, and that being so, the appellant is liable for eviction. Then 4. Sri Sachar, learned counsel for the appellant, has assailed the said finding recorded by the High Court that the appellant has sublet or parted with the possession of the premises and has submitted that mere user of kitchen and latrine by Mohendra Singh, who is the brother-in-law as well as employee of the appellant, cannot mean the appellant has sublet or parted with possession of the premises. In support of his submissions, Mr. Sachar has placed reliance on the decisions of such and such Sri Chitre, Sri Chaitali or Chitale, learned counsel for the respondent, on the other hand, has supported the decision of the High Court and has argued that in fact and circumstances the High Court was right in holding that the appellant has sublet or parted with the possessions of the premises, and he has placed reliance on the decisions of Rupchand Baj Gopichand. Under Section 13(1)(e) of Rajasthan Premises Control Act, the tenant is liable to be evicted if he has assigned, sublet, or otherwise parted with possession of the whole or any part of the premises without the permission. Subletting means transfer of an exclusive right to enjoy the property in favor of third party, and the said right must be in lieu of payment of some compensation or rent. Malad, I also, Malad, in support of that dictionary meaning,
yes,
I also rely on this. Parting of legal possessions means possessions with right to include also right to exclude others. Mere occupation is not sufficient to infer either subtenancy or parting with possession.
Yes.
If the instant case is considered in the light of the aforesaid principles laid down by this court, it cannot be said that the appellant has either sublet or parted with possession of a part of the premises in favor of Mohandas Singh, who is brother-in-law of the appellant and is also employed by the appellant. But then the Supreme Court dealt with the judgment relied on by the respondent and said that there was no subletting.
Okay.
The last judgment I will be relying on, although this is not exactly on the family, this is the case of partnership. This is reported at 2000.
Yes.
The last judgment I will be relying on 2005, volume 1, SSC, page 481. The paragraph 16 and 17. And this is not a case where there is a case of partnership. The term sublet is not defined in the Act, new or old. Paragraph 16, sorry, paragraph 16.
Yes.
The term sublet is not defined in the Act, new or old. However, the definition of lease can be adopted mutus mutandis for defining sublease. What is lease between the owner and property and his tenant becomes a sublease when entered into between the tenant and a tenant of the tenant. The latter being the subtenant for the owner landlord. A lease of immovable property as defined in section 105 of the law is the transfer of right to enjoy such property made for certain time for consideration of the price paid or promised. A transfer of right to enjoy such property to the exclusion of all others during the term of the lease is sine qua non of the lease. A sublease would imply parting with by the tenant of the right to enjoy such property in favor of his subtenant. The different types of phraseology are employed by different state legislatures making the provisions for evictions on the ground of subletting. Under section 21(1)(f) of the old Act, the phraseology employed is quite wide and it embraces within its scope subletting of whole or part of the premises as also assignment or transfer in any other manner of the lessee's interest in the tenancy premises. Well, I'm just pausing here for a moment and kindly see what is the ground in 13(2) in old Act so far as the subletting is concerned.
This is Tenancy Act 1956. West Bengal Premises Tenancy Act 1956. পুরোনো একটা আছে
বই দাও না কেন নেই
Just I'll hand up. Here the definition was not the ground was not so wide. My lord, 13A, may I just reading 13(1)(a), where the tenant or any persons residing in the premises let to the tenant without the previous consent in writing of the landlord transfers, assigns or sublets in whole or in part the premises held by him. That is the ground of eviction. I think one. This is all state rent controls, the provisions were similar all over India. That is why just reading. Now, may I continue with the judgments, my lord?
Yes.
The exact nature of transactions entered into or arrangement or undertaking arrived at between the tenant and alleged subtenant may not be in the knowledge of the landlord, and such a transactions being unlawful would obviously be entered into in secrecy, depriving the owner landlord of the means of ascertaining the facts about the same. However, still, rent control legislation being the protective for the tenant and the evictions is not permissible except on the availability of the ground. Therefore, having been made out to the satisfaction of the court or the controller, the burden of proving the availability of the ground is cast on the landlord, the one who seeks eviction. The Honorable Supreme Court relies on Krishnavati but Hansraj and reiterated view. Those judgments are reported at first one is 1974 1 SCC 289, and the second one is '68, my lord, to SCR 548, AIR 1968 SC 933.
Yes.
That will, you will get the last of the page.
Yes.
The 11 and 12, those are two judgments.
Yes.
Now, the SB Sardar Ranjit Singh's case, my lord, the portion was quoted, paragraph 6. The onus to prove subletting is on the landlord. If the landlord prima facie shows that the occupant who was in exclusive possession of the premises let out for the valuable consideration, it would then be for the tenant to revert the evidence. You also will find nothing in the present case that there was any attempt on the part of the plaintiff, any attempt, I'm consciously using this word, there was any attempt on the part of the plaintiff to prove parting of consideration.
Is there any pleading?
No pleading in the plaint. Only exclusive possession has been parted with. My lord, I can go back to the pleadings also. My lord, page 2 of that paper book. The 5 paragraphs pleading. In fact, paragraph 2 is the subletting. Page 2 of this branch, my lord. Kindly take this, my lord, again. There's not even single word used that it must be against consideration. Page 2, paragraph 2. Only paragraph 2. These 5 lines, my lord, used in the plaint. There's no other pleading. That is, my lord, default in payment of rent and other. And he
Yes.
also, again, my lord, I had shown already that he claims to be the owner of the suit premises after 69. This suit was filed 1981, but in 69 family settlement. My lord, yes. So it was not available in your lordship's
No,
record.
I have got,
Family settlement.
yes. I have
It's
the copy.
available. It is available.
Yes.
Lordship has read out. Yes, yes. If it is available, no, I got it. Another copy xerox. Now may I continue, my lord?
Yes.
Paragraph. And এইটাই তো লাস্ট জাজমেন্ট তোমরা কি আজকে বলতে চাও
It was earlier placed along with an application.
Yes, yes. That was order 41, rule 27
Yes.
application. That
It
is
was
right.
placed
But
with
it
the-
was not annexed probably in the application.
No, it is here.
Or in the original record, most probably it is there. আছে না? Application আছে না?
Yes.
Yes. Now, madam, may I? That judgment, my lord, I had showed the quoted portion. Thus, on the last paragraph, thus, in the case of subletting, the owners lying on the landlord would stand discharged by adducing prima facie proof of the fact that the alleged subtenant was in exclusive possession of the premises, or to borrow the language of section 105, was holding right to enjoy. A presumption of subletting may then be raised to the amount to proper proof of unless rebutted. In the context of the premises having been sublet or possessions parted with by the tenant by adopting the device of entering into partnership. Now this case was in respect of partnership. Even then Supreme Court what held, that is why I will be showing also 17. Rest of paragraph 16, when partners changed in the partnerships, what will happen? In the paragraph 17, I'll
Yes.
don't think that those will be necessary. In the present case, there is unrebutted evidence available on record to show that the family of the tenant consists of 16 members, which includes cousins as well. So family, when Supreme Court refers the cousins is inclusive of the family. In any, the family is joint and dependent for his livelihood on the business running from the suit premises. The tenant has not parted with the possession in favor of any stranger. The brothers, a wife, one of the brothers and cousin have entered into a partnership with the tenant for the purpose of carrying on the pre-existing business in the suit premises. There is no evidence adduced and no material available on record to draw an inference that the tenant has disassociated himself from the business activity, leaving for the partners alone to carry on the business, or that so-called partners are in exclusive possession of having no relationship with the tenant, and the partnership nothing but a camouflage for parting with by the tenant of the possession of right to use tenancy in favor of the persons in possession. The High Court was not right in holding case of subletting, having been made out simply because the sole proprietary business was converted into partnership business. The two part of the judgment, one is said, there should be something to constitute that the consideration being passed.
Yes.
I say that both the courts are in law in holding the subletting in the absence of pleading and evidence. These are the for the subletting. And the first question which I argued already, that he is not the owner also. But these are my submissions. There could not have been a decree of evictions on the ground of subletting because there was no other ground. I had read already both the court judgment. There was no default in payment of rent that has been found by the trial court, found by the appellate court, lower appellate court. And in my humble submission, the the subletting was not proved. In fact, my lord, both the court's judgments are perverse, my lord, to that effect. There was no evidence, my lord, to show that there was subletting.
Yes.
Those are my submissions. Extremely grateful.
But if your lordship kindly fixes up any date, my lord, but I'll complete my submission, my lord.
Next week?
Yes, the 6th of
Running
December.
matter, 6th of December?
6th December.
Okay. So 2 to 16, I have some other determinations with the division bench. That is the difficulty. So it would be appear in the list of January, not earlier than January. January 3rd.
আমরা বলবো।
January 3rd?
Well, I do not have any problem. I learn.
Because my vote on record will not be here. Because the name, probably Friday is the day.
Yes, I am taking the matter Friday only.
So it should be 10th. On 17, 18 or 19.
17, 18, 19 December are the other matters. That is the determination is 20th can be done. 20th I am not going to that effect. So I can take up the matter on 6th or 13th, but I have the
Let it
determination.
be on the 3rd, my lord, my junior council will be.
Okay, okay, okay.
Let it be on 3rd.
Third. Please take down. Scene. Argument on behalf of the appellant concludes. Let the matter appear in the list on 3rd of January 2025 for argument on behalf of the respondent.
This matter has been marked. This is a special.
It is a special asset, not necessary. It is special.
Good.
ওইগুলো দিয়ে দাও। Call the next matter. papers কি আছে কেউ নেই রিপোর্টটা এলো কি করে আসুন কে করেছে Answer, please. Yes, is Jana. কিসে অ্যাডভোকেট ফর কি লিখছেন এখানে রেসপন্ডেন্ট না অ্যাপ্লিক্যান্ট লেখানে নেবেন এখানে এরকম অ্যাপ্লিক্যান্ট না রেসপন্ডেন্ট দিন আমাকে দিন আমাকে দিন ওইটা পুরো দিন কি অবস্থা রেকর্ডটা এখানে উকিলদের ওকালতনামাগুলো কোথায় রেসপন্ডেন্টদের ওকালতনামা কোথায় রেসপন্ডেন্ট অ্যাপিলেন্টের ওকালতনামা কোথায় বাবা, আস্তে আস্তে Please take down. This is an old appeal of 1968. This is being appeared in the list on mentioning on behalf of learned advocate, on behalf of by learned advocate Mr. Snehasis Jana, appearing on behalf of one of the respondents. Full stop. None appears on call. Full stop. It is reported by the department that trial court record has already been raised. Paper books were prepared. Learned advocate for the appellant has received the paper book. Learned advocate for the appellant, Mr. Gauri Prasad Mukherjee, has received the paper book, but no respondent have collected the paper book from the department. Full stop. Considering the pendency of this old matter, department is directed to inform the learned advocate on record, Mr. Gauri Prasad Mukherjee, regarding the adjourned date. Department জানাবে কবে কোথায় আছে কি না। Let the matter appear in the list on 6th of December. দেখে দাও। 6th December.
But I am for the respondent in this matter.
Yes.
But this on the last occasion, Lord, there is an order. If my Lord kindly comes to the order dated 20th of July 2023, the appellants were not appearing. And this is an appeal of the year 1990. And I am holder of Lord the degree in the trial court, which was affirmed by the first appeal court. So it is a judgment of affirmance. The order dated 20th of July 2023 Lord records that even the appellants are not represented. No accommodation has also been sought for on behalf of the appellants. Learned counsel appearing on behalf of the respondent is directed to serve notice upon the learned counsel appearing on behalf of the appellant with an intimation that the matter will appear under the heading hearing of appeal on 8th August 2023.
Yes.
Let the matter appear under the heading hearing on such and such. Pursuant to this direction, Lord, we have already served a notice. I filed not the affidavit of service, Lord, intimating that the learned advocate was not informed about this order. Kindly, let's see the last, the last 3 lines of the order. If the appellants remain absent on the next date of hearing, the matter may be taken up in absence of the appellants.
You have served notice.
Lordship, there was a direction, my Lord, on the second paragraph of that,
Yes.
Lord, the order. And Lord, pursuant thereto, Lord, we have served notice. Lord, the affidavit of service is before my Lord. And Lord, the consequence of non-appearance is recorded in the last paragraph of the order. The difficulty is, Lord, this is an old appeal, and I'm a holder of the degree which was affirmed by Lord, the first appellate court. This is a concurrent finding of fact. Last few dates, dates one. Dates. Duty to see. But I'm told, Lord, even on the last occasions, Lord, there were certain, Lord, the dates, my learned friend says, and the appellant was also absent on those dates.
On Amrita Shankar Roy, Aritra Shankar Roy, appear on behalf of the appellant.
But that was not, I think before 2023, when the last order was passed on
Yes.
20th of July.
In the year
Yes.
2019.
Lordship.
Now, whether Mrs. Bhaswati Chakraborty is advocate on record
But
for the appellant.
Lord, your Lordship will kindly have a look at Lord the letter. Lord, that is Lord addressed to Bhaswati Chakraborty, Lord, the page number 3 of the affidavit of service.
She was the advocate on record.
Yes. And Lord, before mentioning Lord, she was also Lord notified about mentioning before my Lord. On instruction, I see. Right?
No one is appearing today.
But,
Okay, please take down. In pursuance to the direction of this court dated 20th of July 2023, the learned counsel for the respondent has served notice upon the learned advocate on record for the appellant regarding the fixing of date of hearing of the appeal. Regarding fixing of the date of hearing of the instant appeal. Full stop. None appears on behalf of the appellant. Learned counsel appearing on behalf of the respondent submits that the instant appeal is pending since long due to the laches on behalf of the appellant. The learned counsel also pointed out the last paragraph of the order of observation of this court dated 20th July 2023. Full stop. Or the learned counsel for the respondent. It appears from the record that on the earlier occasion also the appellant did not turn up. Considering the situation, it appears to me that the appellant is not at all intending to proceed further with this matter. It's not at all intending to proceed further with this matter. Under the above observation, the instant appeal B and the same is dismissed for default. Full stop. Order under appeal. Order judgment stroke decree under appeal is hereby affirmed. Order. Next, LCR will send down at once to the trial court. Second appeal disposed. Affidavit of service file on behalf of the petitioner is taken on record.
I'm grateful.
Next. Take 137 देखिए दाओ.
Sir, 37 and 38, Devasys Rai is appearing.
Yes.
Yeah, he's told me that he's coming. He's coming.
What do you want? Pass over.
Pass over.
Okay, pass it over.
My lord, in item number 139, my lord, Mr. Ujjal Rai is appearing on behalf of the respondent, my lord.
Yeah.
My lord, I was humbly praying for 1 day accommodation, my lord, to find the appellant, my lord, is not here. My lord. Pray for 1 day accommodation only, my lord.
Very well, not today.
I'm good.
Very pleasure about the appellant. On 11th September 2024, the Honorable Justice Shampad Pal was pleased to pass an order. Accordingly, I have served the notice as well as order to this advocate of the respondent. And thereafter, I have mentioned on that particular day, I have also given the notice. You will also kindly see the order, but due to defect, I should mention thereafter hearing. September 2023. Third parameter. Third parameter. And even the notice order, everything I have given. Thereafter, for mentioning, I have also given. What? So, Equal Lordship, desire and file this affidavit service in this connection. There was an order, that's why I did not.
You were appearing on behalf of the appellant.
Lordship.
This is the appeal of 1996.
Lordship. Transfer report.
In this situation, no one is appearing on behalf of the respondent.
Last. This chain roads, they were efficient.
How many respondents are there?
Hello?
How many respondents are there?
There are so many respondents. Logically, 25 lordship. Case number 26, 30. My paper. Here. They were efficient. অর্ডারটা পাঠাইছি জলসের লোকে ছিলেন উনি ওর কাছ থেকে এটা নেয়নি দেখেন আচ্ছা ঠিক আছে ওরা রেসপন্ডেন্ট আমি দেবারতী রেসপন্ডেন্ট ওকে দেবারতী না ঠিক তাহলে জোসেফটাকে বলে দেবারতী সমাধান করো
My lord, I can convey to Mrs. Shane.
He has served notice. Mrs. Sen has received the.
My lord, kindly fix it on 6th. I will convey it to Mrs. Shane.
It will appear in January.
January. As your lordship decides, my lord.
Lordship.
Otherwise, I was thinking to serve the administrative notice to the.
My lord, I can convey it to the respondent.
That will be better. Very well. I'm fixing the matter on 3rd of January.
3rd of January.
You inform Mrs. Sen.
Great.
Okay. None appears on behalf of the respondents. Planet Counsel for the appellant submits that he has complied the direction of this court in pursuance of the order dated 11th of September 2024. By serving notices upon the learned counsels for the respondent. Let the matter appear in the list on 3rd of January under the same heading.
Grateful.
My lord, in this matter, I am appearing for the plaintiff respondent.
Yes.
This is arises out of a suit for eviction, my lord, on expiry of lease by efflux of time. And both the courts, my lord, granted the decree in my client's favor. And decree was passed sometime in, original decree was passed sometime in 1991.
Second April of 1999.
Yes. Original trial court's
decree.
First decree was passed in 1991. Since then, my lord, occupying the property, paying nothing. There was an injunction application was filed by them. This court also directed to deposit money on account of occupational charges. Deposited nothing. My lord, what I am proposing to your lordship, subject to your lordship sanction,
if your lordship kindly take it up on 6th, I shall see, my lord, whether the learned advocate appearing for the appellant, my lord, could be contacted. As marked as part, my lord. That will, my lord, give him some urge to appear, otherwise he won't. And if on that day, my lord, it appears that he is not appearing, then, my lord, consequence will follow. Absolutely defenseless, my lord. Expiry of lease by efflux of time. Took a defense of holding over, couldn't prove it.
However, I think if the how many appellants are there?
Yeah,
One.
One.
Shailendranath Ganguly.
No. Huh? Yes, originally Shailendranath Ganguly. Somebody has entered appeal.
Substituted. Shailendranath Ganguly.
He died, my lord. His substitution application was filed.
Substitute.
Substitution allowed. Right? There. বলো না নাম
সৌরেন্দ্রনাথ গাঙ্গুলি, দেবেশ কুমার গাঙ্গুলি, রবি গাঙ্গুলি, বোমা মুখার্জি, রিনা চক্রবর্তী, and Meera.
We serve them by speed post.
Insufficient address in ফেরত দিচ্ছে।
Substitution done.
My lord, substitution done, but after that, my lord, we tried to serve them by speed post. The heirs, upon the heirs. It has come back.
Nothing is noted in the memo.
Substitution টা allow হয়েছে। Substitution allow হয়নি? কবে application হয়? Just a minute, madam. Application টা কবে? Allow হয়েছে? ওই দেখ। এতে পাঠাবে কি করে? Substitution allow না। Application আছে? হ্যাঁ? Like, I can't find, my lord, the application for substitution.
That is to be filed by the appellant.
That has to be filed by them. If that is not so, a
take down.
Abatement is there.
I'm passing an order for service of administrative notice. Okay. None appears on behalf of the appellant. This is an old appeal pending since 1999. Learned counsel, senior counsel appears on behalf of the respondent, submits that the appeal has not got no merit. Accordingly, the appellant has lost interest to proceed with this appeal. Considering the situation, it would be appropriate for this court to direct the concerned department to serve administrative notice upon the appellant. Accordingly, department is directed to serve the administrative notice upon the appellant and file a report to this court on the adjourned date. Let the matter appear in the list on 3rd of January.
3rd of January.
Before rising,
Before
item number 126, my lord was kind to make passover. The other side is also is an application for recording of death, my lord. Only. The legal heirs are already on record, my lord. The application for recording of death, my lord. My other side is also here, my lord.
My lord,
If your lordship, item number 137, the application for substitution is there, but that is not traceable, I think, because it is written cannot here. It is written, I am supplying the copy, let it be treated as an application, and so long the application is not traceable, let this application be kept on record and be listed before your lordship.
It would be appear in the list, no issue. Next day.
131, I am supplying the copy of the application so that the cannot here be deleted and the applications be listed. হ্যাঁ ডিলিট করে দিই সেটাই বলছি না না ক্যানটা তো নেই বলছে ক্যান নট হিয়ার বলছে ক্যানটা
Can 2 of 2020 are not in the list.
can I am supplying the can 2 of 2001 the Xerox copy of the 2 applications in 2 appeal let that 2 applications be listed on the next day
Already list is there.
List is there but they treated as an original and be
of hearing I will treat that, no issue. At the time of hearing I will take up that matter. Okay. At the time of hearing I will take up the matter, no issue.
I'm getting
Today is not possible.
Next Friday, I have some personal difficulties.
Next Friday, I have also some primary. Okay. I have some division bench to carry out.
143 LCR is not here, my lord, but I inquired that the LCR has arrived long back. 143.
Paper book, second judge's copy, one paper book, 143. I have not called the 143.
No, my lord, LCR, so that there's a direction so that the LCR
it would appear in the list, no issue.
It will
What
appear,
you want?
but without the LCR, my lord, there will be problem. Again,
LCR is there, not there.
LCR arrived, but it is not tagged with the record.
দেখেন ডিপার্টমেন্টে নোট দিয়েছে তো এলসিআর রিসিভ করেছে কিনা এটা দেখেন আপনি হিয়ারিং এটা আমি যোগ করব ঠিক আছে ঠিক আছে
Okay,
no issue.
Lordship, 145 and 147, I had mentioned it earlier, your Lordship had fixed it on 22nd November. But then as the LCR was not there, the matter was not taken up. Today also, due to paucity of time, the matter could not be taken up. If your Lordship could fix this on next Friday at the top of the list. These are very old matters, Lordship. Please, Lordship. These were
supposed the list, how can it be?
Lordship, this was supposed to be come on 22nd November.
Appeal is there. Your appeal is for 2006.
2005.
2005-6. I have 1990 appeal.
Lordship, if you
68 appeal.
Lordship could fix it on next Friday. We had mentioned it
Next
on
Friday, I
4th.
have some difficulty.
Lordship,
Next
then
Friday, I will not
next
be there.
week, any day.
Let it run in the list. I will take up the matter. No issue. I cannot fix the order. I can available only in the January. Not earlier than that.
But with regard
I have to preside over a division bench.
My
That is the issue.
Lordship, may I give one thing, my junior, one small prayer, innocuous prayer, 146 matter. This matter, Mr. Arnob Roy is appearing on behalf of the Lordship, the appellant here, but his junior is very. In this matter, my lord, the messenger cost due to this has been already submitted. Messenger cost. I just came to know.
Special messenger cost. For what?
Now, for the messenger, for the filing and the bringing of the court
LCR.
Court bill. And one thing, special prayer, Lordship, the 6th December, the next Friday, it will be taken up. I will not be. Some of the may not be.
It will be taken up in the January 2025. Okay.
Lordship, one prayer, my lord. Item number 140. Earlier, I appear on behalf of the respondent. Your Lordship directed me to appear on the next day, but the client has taken out the brief. But they have not taken no objection. That is the whole difficulty. But brief is not lying with us. Item number 140.
140? 140? No. Item number 140.
140, my lord. Your Lordship called on and directed me.
Administrative notice দিয়েছি। Okay. Okay,
The client has taken now the brief, my lord, from us.
I understand. That's why I'm directed to serve administrative notice.
That makes sense.
Let Mr. Mitro is appearing online.
Yes.
Malad.
My lord, union has preferred an appeal, my
Malad,
lord, and
Malad.
the appeal court is in season of the matter.
Malad, that bench has requested your lordship's court to keep the matter Malad, after Wednesday.
No,
Any
yes,
day
my
after
lord.
Wednesday.
My lord takes original sites on Friday, make appear
Next
on Friday,
Friday.
my lord.
Okay. So the issue is that next Friday and thereafter I would not be able.
Circuit. Malad going to
No,
circuit.
one of my brother is going to circuit, so I have to sit with a division.
Oh,
bench.
division
My
bench.
lord, then may it appear on
Thursday,
my lord.
Thursday, any
Thursday,
if it could be any time subject to my lord's convenience.
hearing the matter on Thursday, anytime, my lord, subject to my lord's convenience.
It can appear in the list on 19th and earlier. 19th of December, not earlier.
19th of December.
Not earlier than that. It will be better to fix on January.
No, my lord, in case, my lord, my learned friend's appeal is dismissed, my lord, then we would come back to my lord.
I would not be available till
My lord,
till
my lord,
16th.
my lord.
No, from 2nd I would be there until 16th.
Let it be on 19th, my lord, 19th.
Let it appear.
Let it.
Lordship, your 19th?
Yes.
Yes.
19th at 2 p.m. Lordship, kindly fix the time. Time at 9 p.m. On the 19th, whatever may it be, well, kindly keep it. Kindly make an order. Kindly make an order recording that it's on 19th for the benefit of the bar.
I have no objection. The submission of Mr. Mitra.
Kindly record an order, keeping it on 19th at 2 p.m.
Okay.
Making the submission on all our behalf.
Please take down. Having heard the learned counsel for the parties, let the matter be fixed on 19th of December 2024 at 2 p.m. under the same heading.
Deeply appreciated.
Grateful.
Great, thank you.
Grateful.
Oh, it is the one. The appellate side matter was being taken up together. The same order may be passed in that as well. Great.
Item number 2,
The petition.
Lordship, in this matter, Mr. Nag was addressing your lordship on behalf of the respondent. There's some personal emergency which has cropped up and he's not in court.
Okay.
So he has requested me to convey this to your lordship and if possible, a date may be fixed or it may be adjourned, whatever is convenient to you.
Just fell from my lord's thoughts that my lord will not be taking the matters till 16th.
Yes.
My lord, there is one recording, my lord, which I would pray that be rectified. My lord, with respect to the submissions of the petitioners, Mr. Bojumdar has not concluded the submissions.
So if they,
Mr. Bojumdar was only demonstrating the broader prospectus of this case. My lord may remember regarding the weights of the cylinders and all. But we are yet to rely upon the judgments which we want to place before them.
Lordship,
The pilot has already recorded.
oh, achha.
It has already recorded that the.
So Mr. Mojumdar has not concluded.
No, he has not.
Okay.
But we
On the last day, you have said that
He was there, but since
we are in impression that he has concluded. That's why I'm.
asking
Yes, that's why.
Judgments are yet to be placed. Let the matter be.
If today Mr. Mojumdar can.
then I can take note.
They can. I can. Mr. Bojumdar is not here, but I can proceed with the matter, and I can place the judgments. And
You can place it because for these two matters I have
yes,
fixed the entire day.
It's been pending for long.
Yes.
So I can start today and place that.
You can start. No
judgments. And if Mr. Mojumdar comes in between, fine. Otherwise,
yes,
they can.
I'll take notes and then
Yes,
we
yes.
will commence with our argument on.
Just do.
But in the
larger.
Give me my notes. Fine, good. good. আছে তো হ্যাঁ ভেতর ওখানে লিখবো না দেখি এটা কি আছে তো অর্ডার কপি না 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 এতে কিছু নেই শুধু এইটুকুই আছে
My lord, may I?
Yes, can you proceed?
Yes, my lord, a supplementary evidence.
Was there any direction?
আর কিছু আছে কি না না আর কিছু নেই তো দেখা
Yes. One page was missing, respecting an appellate order. One page was missing with respect to the appellate order. I have given the entirety in a bit of a supplement.
We haven't received any copy of.
You have a copy at
I will. Well, for the time being, this is.
What is this? The one page of one page of appellate authority's order.
That's for the records that I am not incomplete on that. Therefore, I have.
Very. No, that is not right.
My lord.
Don't. Let me proceed with the.
No.
Yes.
Because I should also get a chance to see whatever is being placed.
Only the supplement, the appellate.
Maybe, but a copy.
Yes, you have to you serve a copy.
I will serve. I will serve.
Okay.
Let me just fish out from the bunch of documents and I'll serve. Now, let me begin from where Mr. Mujumdar has left.
No, it is better to recapitulate the matter as is.
Absolutely, in entirety. But I am a LPG dealer, and on a regular basis, an LPG dealer is subjected to different inspections from the mother organization, which is the Indian Oil Corporation.
Yes.
Now, my lord, under there are certain guidelines based on which these inspections are carried out by the oil sector companies on a regular basis, primarily in the godowns as well as in the dealership showrooms.
Yes.
And these inspections are again guided by a set of guidelines, which is known as marketing discipline guidelines. These guidelines were introduced long ago. The latest guidelines, my lord, applicable for this case is 2022, which in short is referred to as the MDG guidelines.
Okay.
Now, my lord, this particular inspection, which was carried out sometime in the month of July 2024, here, weighments of the cylinders were taken by the concerned inspectors.
Yes.
My lord, I am giving a brief overview of the case, and then I'll go to the specific thing.
Yes.
While making weighments, according to the writ petitioner, they have defaulted in taking weighments. The weighing parameters were defaulted, the records were defaulted, and therefore, according to the writ petitioner, any action taken on this defaulted records is arbitrary and cannot be and is not actionable. Because what has happened is that based on these records, Indian Oil Corporation has started a departmental inquiry. The inquiry is at two stages. On first stage, they, based on the findings, they have said that I have committed certain defects, and therefore major penalty was accorded. And in the second stage in appeal, which was appeal made by the writ petitioner, certain findings were curtailed, but the major penalty remained. And all these findings were primarily based on the measurements taken by the inspectors at the time of inspection. Now, my lord, how these measurements were taken?
Yes.
Let me get back to the constitution of a LPG cylinder. My lord, LPG cylinder essentially has a dry weight. What is dry weight? It is essentially the structure of the weight is the structure of the cylinder.
Yes.
The structure of the cylinder, that is the iron weight essentially, is printed over it. My lord, we find that it is printed by the manufacturer, the Indian Oil Corporation, say 15 kg. Now, the capacity of the gas, or rather the gas or volumetric proportion of the gas, is being sold to the consumer. The weight is 14.2 kg. Now, 14.2 kg essentially means 14 kg, 200 grams. Now, my lord, as per the legal method, this is the pressurized cylinder. It is coming from the manufacturer. The entire weight, the gas, is being measured at the end of the dealer.
Yes.
Now, what is the permissible deviation which is allowed under the legal metrology packaged commodity rules 2011? My lord, that is 150 grams. So, therefore,
150 gram deviation are allowed.
Is allowed. Not on the upward cycle, but on the lesser side. Say, for example, 14 kg, 200 grams is the ideal weight which should be sold to the consumer. If the deviation is within 150 grams on the lesser side, it is allowed. Though the act says plus minus 150 grams. Now, my lord, clearly appreciate that 150 gram is, if to be measured, there has to be a certain sensitivity of the measuring scale.
Yes.
Now, my lord, I have referred to the MDG, which is the marketing discipline guideline. The marketing discipline guideline is a set of rules which has to be adhered to by the dealers, and it also becomes applicable to the inspectors, because it is the same guidelines which has to be adhered to everybody. My lord, the guideline says that there has to be a platform scale present in each dealership, which was always there. First violation, my lord, it is admittedly when the inspectors came, they did not weigh the cylinders on the platform scale. Now, the platform scale has a sensitivity which is having 3 places from the decimal, so that it can actually capture the deviation in grams. That is the necessity under law. Now, my lord, they have weighed on a handheld scale. Even the handheld scale has that sensitivity. But the question is, my lord, in what manner the inspectors have captured the deviation? Now, my lord, I will invite my lord's attention to the writ petition and the annexes. My lord, will bear me for the minute. my lord kindly comes to page 80 at volume.
Page 80.
Page 80 at volume 1 of the writ petition.
Yes.
My lord, see, my lord, here these payments were taken by the inspectors, my lord, and I am drawing my lord's attention specifically to those cylinders which are found to be at fault according to the Indian Oil Corporation. My lord kindly comes to serial number 3.
Yes.
My lord sees the variation is 0.02. Now, my lord, had there been the proper recording of the weights, the inspectors, if they had followed the LTG guidelines, they would have captured the variation in at least 2 places of decimals. Because 0.20 essentially means 200 grams.
Yes.
But 0.2 does not say, or because the variation has to be more than at least 1 place of decimal. Otherwise, 150 grams of deviation could not have been captured. My lord, I'll just cite one pictorial description just for my lord's understanding as to how things are placed over there. Reply it again. You kindly seize this particular pictorial representation. My lord, kindly sees this is a handheld machine.
Yes.
This is a handheld machine, and my lord sees the sensitivity of the machine. It actually describes the weight from 3 places from the decimal. Now there is a platform scale.
Lordship, I'm little provoked to interrupt. I'm sorry. Certain things we have learned from our seniors only. Whatever be it, it has to be part of the record. We can't just hand out documents like this, maybe for convenience, but it is up to your lordship.
This document you are saying?
No, but I'm being shown a different.
Okay, okay.
Anyway, but these ought to have been part of the document.
It is part of the record. It is in the reply. Just for the continuity of the argument, I have shown, and I have also.
This is I am not taking this matter only. He's just trying to show that.
Yes.
So I'll leave it to your lordship, but it's something that we've learned from our seniors only, not to just hand out documents.
Okay.
It is for the understanding of the court, as well as I have also tendered the same machine photographic impression to you as well.
Then we can
so there may be
the reply. I do not want to trouble my lordship on taking another sip of document. Already the document is quite voluminous. Therefore, it is being placed.
Okay.
Need not take into cognizance just for the understanding. Sir.
So this is the hand machine.
This is the hand machine.
So
and the same is a platform machine, which is a fixed apparatus where the cylinder is being placed and it captures the weight.
So after decimal, there are 3 digits.
Yes, there are 3. At least there has to be 2 digits. Otherwise, the deviation of 150 grams cannot be calculated.
Yes.
It will always come in whole figures, either 100 grams or 200 grams or
300 grams.
But it will the extra 50 grams cannot be captured, which is the crux. My lord, this is my lord. Now, my lord, I have shown that this is the basis of the document based on which the entire departmental proceedings continue.
Okay.
What are the allegations? The allegations are that the dealer was supposed to weigh the cylinders, and the weighment has not been done. My lord, before going to that, the contention is, my lord, kindly see the remarks portion at page 80. Assuming that these are defects, my lord, so far as defects are concerned, serial number 3, 4, 5, and 9 and 8. These are the cylinders which are found defective.
3, 4, 5, and 8.
Yes, on the first lot, and my lord kindly sees the next page. Serial number 4 and 6 are found to be defective, which is beyond the permissible limit. Now, my lord, in the same report at page 80 as well as page 81, my lord, below the tabular statement, my lord, see serial 2. It says electronic weighing scale available with least count of plus minus 10 grams. It says yes. Therefore, the authorities admits that there was an electronic scale available and they did not comply with the MDG guideline. Now, my lord, in both these two sheets, kindly glance on the remark portion. Nothing is written.
Where is the remark portion?
My lord, on the extreme right side of the sheet, page 80. And let's see the tabular portion. The last column is remarks.
Remarks.
Nothing is written. They did not found anything objectionable. Now, my lord, I am coming back to the genesis of MDG guidelines. My lord, why MDG guidelines were formulated on the first place? My lord, the government of India, now my lord kindly comes to the writ petition. Brief me. One of the reasons why the MDG guidelines were introduced, it was introduced only on the allegations of tampering or any foul play committed by any of the intermediaries after the pressurized cylinders are released from the manufacturer. Now, my lord, that is the fundamental issue as to there has to be an allegation of tampering or allegation of malpractice with respect to the constitution of the cylinders which are intended to be sold. If my lord kindly scans the page 80 or page 81, which is the essentially the field report, it does not speak about any tampering of seal or any tampering of the cylinder in any manner.
Where is the guideline?
My lord,
point.
Yes, madam. Kindly come to page volume.
Yes. Marketing discipline guideline. Yes.
The Minister of Trade to Petroleum that public sector while marketing companies and malpractices that outlet dealerships. Action is taken in case of established repeated against erring dealers as per NDG guidelines. NDG guidelines. Now, under one of the number of irregularities related to public sector offices, retail outlets in the last year, and then the nature of irregularities. Stock, suspected product alterations, adulterations, overcharging, unauthorized purchase sale, unauthorized fitting, seal stamping. So far as my lord, the payment issue is concerned, it has directly to deal with fundamental issues over here. One is suspected product alteration, and other is unauthorized fitting, seal tampering. Because these are the two elements which impacts the cylinder per se. Now, my lord, these two allegations are not there. There are no allegations as to tampering or adulteration. They are outrightly coming up to the dealership showroom or to the godown, weighing and found that there is a deviation. Deviation not within the permissible limit as per them. Now, my lord, there is a fundamental question to be understood that Indian Oil Corporation is the manufacturer. They are manufacturing pressurized cylinders and they are subjected to statute under the legal metrology package commodity rules. They are now alleging, or rather by way of implementing the MDG, they are shifting the onus of penalizing the dealership, because of the cylinder demand. Whereas legal metrology says that if it is a pressurized cylinder, the onus goes back to the manufacturer. So, in the guise of legal metrology, in the guise of this marketing discipline,
who filled the gas?
It is the Indian Oil Corporation.
Indian Oil Corporation.
They are the manufacturer. For the understanding, they are the manufacturer.
Yes.
They manufacture cylinder, they manufacture gas, and they ship it to the dealers. Dealers only buy it from them and then recirculate in the market. Now, because this MDG guideline says that you have to weigh, and they allege that weighment has not been done, and there is a perceptible gap with respect to the weight which is to be sold. Therefore, I am liable. But as per the Legal Metrology Act, the liability rests upon the manufacturer for any manufacturing defect. Because filling of the gas is also a manufacturing activity. The dealer has no business to fill the gas or take out the gas unless, my lord, there is an allegation of adulteration or suspected tampering of sale.
Yes.
Now, my lord, kindly comes to page 14.
Page 40.
49 of volume.
Yes.
My lord, this is the MDG guidelines, my lord. And I am inviting my lord at 1.4C. Sorry. My lord, C says all the cylinders taken out for delivery should be checked for correctness of net weight on the platform type digital weighing scale of least plus minus 10 grams prescribed in the legal metrology packaged commodity rules 2011. So, my lord, this NBG guideline also prescribes the sensitivity under the platform scale, and that is plus minus 10 grams. The deviation permitted under the legal methodology is 150 grams with respect to package sugar. But this MDG goes back further. It increases the sensitivity to plus minus 10 grams. Therefore, the necessity of 3 places from the decimal. 1 kg and 10 grams is 1 by thousands. As amended from time to time, cylinders that have net weight beyond permissible limit prescribed in legal metrology commodity rules 2011 as amended from time to time should be segregated and returned to the concerned bottling plant. My lord, with respect to this last line, my lord, remembers I showed that in the remarks portion nothing was mentioned. My lord kindly considers an investigative entity comes up, finds out certain allegation, prima facie there is a deviation according to them. If they find that there is a deviation, it would have been incumbent on the authority to immediately seal those material and to disclose certain remarks that please, these are under suspect, do not circulate with the customers. That would have been the normal procedure or an acceptable procedure. Nothing has been done.
No, you have to weigh them in the flat weighing machine.
Yes.
Flat digital weighing machine, flat platform. Thereafter, you have to load them in the trolley.
Correct.
That is the system.
That is the system.
And there is permissible 10 plus 10 or minus 10 grams. So it is the allegation you have loaded them in the trolley.
My lord, what I'm submitting is that at that juncture, my lord, this is a different issue altogether, that whether I have weighed or I have weighed, put it in the trolley.
Yes.
Because I will show it from the document that the inspectors have came in my godown early in the morning around 7:30 a.m. when the official operations were yet to begin. That is a different context, my lord. I am absolutely on this point that assuming the inspectors have weighed, I am more stressing on the fact that the document which you have created by weighing out, that itself is not acceptable under the MDG guidelines. That is one.
Yes.
Second, assuming, my lord, the inspectors have taken note that this is, according to them, this is not permissible and it is beyond the standards. The only logical thing left to the inspectors was to put a remark that this is seized or this is being marked out and this is not to be certain. Because this is an evidence. Once they are found, otherwise the whole thing again becomes contested.
Yes.
Well, that was not done. Well, why I am submitting that post this inspection, immediately the inspectors moved on to the show and they summarized the entire reports. Now, my lord, let me place the entire reports, which was handed over to the owners of the dealership. My lord, it is at page 7. Page 7. I get difficult because of the little observation.
What is this?
Lord, this is the summary. Why I am saying summary, my lord? My lord, kindly consider the left-hand side of the page 7. Left-hand side of the left-hand column of this particular statement. My lord, just above the middle, my lord, see there is a row, random SQC of cylinders.
Random SQC of cylinders.
That's random exclusive of cylinder. That is the quality control of the cylinders. And then kindly comes to the mentioning of the serial numbers of this. These are serial numbers of the cylinders. Now, kindly see what is written. Seal is okay.
Yes.
That means the seal is okay. There is no allegation of
Tampering of seal.
tampering of the cylinders. And they lay out the respective weights. My lord, kindly see the weights. It is not adhering to the prescribed sensitivity as per the MDG guidelines. My lord, then at the below, my lord, kindly see the date given 14/7/23 at 2 p.m. Therefore, as I said, my lord, in the morning the inspection was done in the godown. Then they came down to my showroom. They summarized the entire findings, and they have written the date and time. My lord, I am coming to the rest of the written down observation with respect to the other allegations. I am only concentrating on the weights, my lord, because each issue will have to be dealt with individually. Now, my lord, kindly comes to page 70.
70.
70. And there are multiple allegations. I am only concentrating on the weight first, then I will satisfy on the other.
Yes.
Page 70. My lord, let's see. This is an email coming from the authorities, and just the third line from the end, or rather the fifth line. My lord, kindly see inspection period 14 July 11:12 something AM. My lord has seen that?
Yes.
Yes. What is the status? It is finalized. Now it says MDG applicable? No. MDG means whether any actionable is to be done as per the MDG guidelines. It says no.
72.
Page 72. Well, annexure P3.
Annexure P3.
Yes. My lord, this is the report inspection post inspection.
This matter.
Yes, 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 my lord. Kindly comes to the fifth line from the last.
Fifth line from the last.
Here. My lord, says inspection period to 14
Yes.
July 2003.
Yes.
23. So it was the inspection was on 14 July 2023. Such and such time. My lord, the status shows that it is finalized. And MDG applicable, it says no. That means no actionables are to be done as per the MDG. Everything is fine.
Yes.
So, my lord, with respect to the weights, even the inspectors, prima facie, did not find anything which is beyond their established protocol. Whatever has happened as an afterthought. Prima facie, my lord, there was no deviation. Or according to the field officers, there was nothing spurious or nothing to be alarmed about.
So this is the mail issued to the petitioner.
Yes.
By the Indian Oil Corporation.
Now, my lord, may I just show what is the statute? Then that will clarify with respect to the weights. but I'll be referring to this package. This is Legal Metrology Package Commodity Rules 2011. That kindly comes to page 64. I will just refer to the relevant sections which will be applicable for adjournment. Page 64, 64, yes. The beginning of the Legal Metrology Package Commodity Rules 2011. My lord kindly sees section 2B. My lord, the definition of dealer. I am a dealer. What are my liabilities? Or my definition is dealer in relation to any commodity in packaged form means a person who or a firm which carries on directly or otherwise the businesses of buying, selling, supplying or distributing any such commodity, whether for cash or for defer payment or for commission, remuneration or other valuable consideration, and includes a commission agent who carries on such business on behalf of any principal, but does not include a manufacturer who manufactures any commodity which is sold or distributed in a package form, except where such commodity is sold by such manufacturer to any other person other than a dealer. So, my lord, I am squarely within the definition of this dealer. Now, my lord, next page at page 65 comes at subsection D, the definition of manufacturer.
Yes.
Manufacturer in relation to any commodity in any package form means a person who or a firm which produces, makes or manufactures such commodity and includes a person or firm who puts or causes to be put any mark on any packaged commodity not produced, made or manufactured by him or it, and the mark claims the commodity in the package to be a commodity produced, made or manufactured by such particular firm as the case. My lord, there is no doubt in this particular case that the gas cylinder per se, including the gas, is manufactured by Indian Oil Corporation. Now, my lord, finally comes to section 21, that's page 85. The relevant portion would be section 21, subsection section 1 and section 1 and gets to inspection of quantity and error in packages at the premises of the wholesale dealer or the retail.
Yes.
And it says ordinarily any test in relation to net quantity copied in the package shall not be carried out at the premises of the retail dealer or the wholesale dealer unless a complaint is received by the director or the controller or any legal metrology officer to the effect that the package sold or delivered to the complainant does not contain the quantity declared on such package or on the label affixed thereto. Or then matter the director or the controller or any legal metrology officer has reason to suspect that any package has been tampered with or that there has been any pilferage or leakage of the commodity contained in the package. My lord, if I may take the gist of this particular section and relate the matter to this case, my lord, it is not a case of the Indian Oil Corporation that they have acted on any acquisition by any of its customers that this dealer has been accused of pilferage or the dealer has tampered with any seal. In the context, my lord, under section 21, the law clearly says that if there is no allegation, no inspection can be done. My lord, kindly comes to section 22 at the next page. Establishment of maximum permissible error on the package. My lord, I am specifically emphasizing on subsection 2.
Yes.
While establishing the maximum permissible error in relation to the net quantity of commodities contained in packages, due account shall be taken to the following causes which may lead to variation in quantity, namely variations caused by unavoidable deviation in the weighing, measuring or counting the contents of the individual packages that may occur in good packaging practice. B. Variations caused by ordinary customary exposure to conditions such as climate, transport, storage, or the like that normally occur in good distribution practice after the commodity is introduced in trade or commerce. And C. The variations due to the nature of packaging material or content. My lord, this is a pressurized cylinder. So, the only way or the manner the variation may happen in weight after manufacturing is by atmospheric interference. It is a gas, pressurized cylinder. Neither there is any allegation to that effect, neither there has been any observation. And this is only a passing reference because it is something connected to the issue of permissible error on packaging. Now, my lord, may I come to what is the permissible, which is most important?
Yes.
My lord,
So permissible error on packages means permissible error due to the nature.
Yes.
Due to the nature deviation.
Yes. If there is a finding or there is a probability of having a variation under influence of nature, that has to be taken into consideration. Or else, my lord, the deviation ought to have happened due to human intervention.
Yes.
There is no three-way. Only two possibilities, either by atmospheric interference or by human interference. None of the issue has been in my matter. Now, my lord, kindly comes to page 91. My lord, I am referring to the first schedule.
Page
91.
Page 91. Yes.
My lord, kindly sees the first schedule 1, table 1. Maximum permissible errors of net quantity declared by weight or by volume. My lord, this is a gas declared by weight or volume. My lord, kindly sees Roman 8 in the serial number, Roman 8, my lord, 10 kg to 15 kg. My lord, the gas is sold of an ideal weight of 14.2 kg, that is 14 kg 200 grams. What is the permissible limit of deviation? My lord, 150 grams.
You are referring?
My lord, I am referring to Roman 8 in the serial number at table 1.
Yes.
My lord, the gas which is sold is 14.2 kg. That is an admitted.
14.2 kg.
So 14.2 kg means it comes within the band of 10 kg to 15 kg. My lord, says 10,000 grams, which is 10 kg or 15,000 grams.
Yes.
So the permissible weight variation is 150 grams. So if any commodity falls within 15 kg bracket, the permissible as per law, as per the Legal Metrology Act, is 150 grams.
Yes. Yes.
Therefore, my friend, one is that the findings itself. First, my lord, the finding itself, finding of the weights by the inspector does not subscribe to the prescriptions of the guidelines set out by the oil company itself. My lord, on course, as I have shown, plus minus 10 grams. If it is plus minus 10 grams, therefore the sensitivity has to be captured with 3 places from the discipline. That is their own guideline. They have not subscribed. My lord, coming back to the legal methodology, which is the statute. That statute says that the permissible limit is 150 grams. And under what circumstances? One had to accuse the dealer of having a weight variation. Unless there is an allegation of tampering, there is no way a dealer can do it. Now, I will kindly ask you page 156. 156 of the, that is according to page 156 of the order first in appeal. But with respect to the payment, I have already submitted, and this is with respect to the allegation of unaccounted sales and shortage of domestic silver. Both the issues are taken together. Both the issues, for the understanding of the facts.
No, there are charges of two issues.
First is with respect, major charge was with respect to payment. The subsequent one is with respect to unaccounted sales and loss of cylinders. And the third is extremely minor, which was not delivery men was not having adequate informed. These are the two essentially major issues which have been dealt with.
Page 136 is shortage of domestic cylinder.
Yes. Now, more or less, there are many technicalities over here. Essentially, what was happening is that to call out this information, which is 11 cylinders were found on the date of inspection. Now, out of 11 cylinders,
Found to be short where? The showroom.
From the accounts.
From the accounts.
From the accounts.
Say 100 cylinder has been sent to you.
Yes.
We found 89.
They are sitting. Yes, they are sitting on the computer. They are telling, and they are founding. They found that out of 11 cylinders, 2 cylinders are physically missing, and 9 cylinders are out of stock.
Out of stock.
Yes, that means the stack is not explaining the absence of the cylinder. Now, on the very particular day, that is the 14th, then again I will come back to the summary of their findings. It is documented that the portal which was managed by the internal corporation was out of function for a large period of time, immediately before the inspection. Therefore, the accounts was unable to be updated, and their 9 cylinders were actually returned back to the manufacturer, and 2 cylinders were sold to a new customer, and therefore the gap of 2 cylinders. And how did they substantiate that? My lord, again will come to page 7. One second. following.
Yes.
I'm sorry, page 70.
70.
78.
78.
The summary of latex. Now, my lord, kindly concentrate on the left hand side written note. May I read out for you? One number XCH4 and two numbers PRE, while this returned vessel should not be issued and submitted with HTML problem. Like HTML is essential. And then, my lord, due to HTML's problem, partial surrender and not be done on 13/7. Reference WhatsApp for before on 13 at 6:30. SAP is not functional for past 3 minutes. For past 30 minutes, any issue related to SAP slash SAP log failed, etc. to be handed over once SAP is up. That means when the portal is down, once SAP is functional, automatically all the records of the remaining cylinders which are found on the upload. Now,
SAP means the portal.
Possibly a software in the portal. HDMS is the portal. So essentially it means that SAP is some sort of
SAP is non-functional.
Yes.
For past 30 minutes.
Yes.
Any issue related to SAP error, SAP lock failed, etc. to handed
over
once
SAP is up. So, my lord, this assuming that something is pending and this has to be uploaded once it is functional. Let us assume for the time. Now, my lord, what happened? Now, my lord, kindly comes to page 136. What was the recording of?
AC on. Yes, page
130. Unless this is the recording of the affidavit. Page 136 and going to the bottom paragraph, start with Roman. Page 136.
Yes.
The kind is unaccounted sale of up to 50%.
This is the order of the appellate authority.
And it starts with A, which is essentially the first paragraph is essentially the observation of the original orders. Now, my lord, if I turn down to next page, see the findings of the appellate authority.
Now, what is the A uncounted?
Unaccounted sale of up to 50 failed cylinders qualification. Brackets supplied by ONC that subsidized the detected during inspection and on the date of inspection. This includes supply of feed cylinders to customer, including customers already transferred, terminated, paid, logged, and updating for a customer in the ONC software by distribution staff, whereas cylinder has actually not been delivered. Transfer of subsidy to customer bank. all materials supplied to such customers sales. It also includes cylinder sales account and the selling both permitted to subsidized 14.2 kg/5 kg cylinder that are effective that's not the category customer. It will also include mismatch between filled and empty stock. Although empty and filled and empty combined stock found to be correct by clause number 2.5 in bracket
Minor irregularities.
Then, my lord, the IDO has concluded that according to AC4s and ERBs relating to the accounting experience, AC4 means the first receipts issued to the first customers, and ERB means whatever cylinders, my lord, are found to be of underweight, those are again sent back to the manufacturer. Pending to the accounting STMS on 37 as mentioned in point number 3 above, 11 feet 14 and 918 14.2 kg cylinders are found in excess. So unaccounted sale of 11 numbers of domestic cylinders by established. My lord, essentially it is not 11 and 9, it is in total 11. That means 9 cylinders and 2 cylinders.
Yes.
Then, my lord, finally comes to the investigation findings with respect to this charge.
11 filled 14.2 kg cylinders were found deficit.
Yes.
And 9 empty 4.2 kg cylinders were found in excess.
Yes. My lord, it does not mean that it is 11 and 9, that is 20. It meant it is the total is unaccounted sale of 11 numbers. The wording has been made in that.
Yes.
Then, my lord, kindly comes to the surprising part is, my lord, the investigation findings.
Yes.
Now, my lord, even at the appellate stage, the appellate authority can initiate investigation, verify as to what are the actual scheme of. My lord, kindly see the investigation which has happened there. Post, after this inquiry proceedings were in process. My lord, see investigation. I am reading out from the last time. The investigating officer tried to get in touch with the district several times after 17 days, but attempts to get connected on as one partners were not responded to by partners of essentially the partners were not responding to phone. My lord remembers the original investigation happened on 47/23.
Yes.
So now
there is the inspection.
Yes, original inspection based on which all these things have started. Now, my lord, that after the matter went to appellate authority, again an investigation happened. What is that investigation on 14/11/23? My lord, the last 2 lines. I think. Finally, investigating officer reached go down of Mrs. And even after reaching there, contacted the case partners as they were not available. While visiting at the distributorship on 7:48 AM, it was found that daily operations started. As partners were not available and could not be contacted on the phone, procedure of investigation was started in cases of. So it was Patra, a delivery man, who was also carrying 10 cylinders. One cylinder out of 10 was found underweight. One register was found updated. 100% without PC record on date certificate. Relevant eviction. As on 14/11/23, partners of Mr. contacted. Finally, contact could be established with partner of and she was requested to present by investigation. Then, my lord, the investigation again happened on 27/11/20. And what transpired? Investigating officer investigated before starting of operations. Surprise inventory was taken in presence of the partner Maruti Shara and inventory My lord, I pause for a moment. My lord, this is a dealership or any dealership as a matter of fact deals with cylinder in hundreds and thousands of number on a daily basis. And the stocks are continuing. If I have a gap of stock in the month of July, and if the stock is found to be not matching, my lord, that deficit will always continue. Because this is, if a physical cylinder is missing, under no circumstances, I am going to bring in another cylinder in some way or other and try to justify. Because every cylinder is serialized, every cylinder is recorded.
Marked, recorded.
Yes. So, if I have a gap in my stock, the stock will continue, it will show even at the end of the year. My lord, on July 14, allegation was that there is a gap in stock. The record also says, because of SDMS error, some inputs are to be given, please give that input. And in the month of November, they say, there is no gap in the stock. My lord, the report kindly clearly shows this. If this is the situation, the recording of the appellate officer clearly says that there is no gap in the stocks. Notwithstanding this, my lord, I have satisfied or I have tried to satisfy the appellate authority by giving physical reports as to what happened to the stock on 14th of July 2020. My lord, the same
Inventory was matching with previous day closing stock report. So previous day means the day 26th of November 2023.
Right.
What is the closing stock that was matching with the inventory in the next day?
My lord,
that is the regular business process they are going on.
the argument may be forwarded. May I think aloud, my lord, for once. That what is the meaning of closing? Does the closing stock means stock for the day, or the closing stock means essentially that is the stock details till that date? My lord has to keep in mind that the entire stock is essentially annexed to a software. So the stock closing essentially means that the last day stock closing is the final record with respect to my entire business operation. If there is no gap, as alleged has been found in the month of November, there could not have been any gap. Whatever gap which was alleged in the inspection report, that has been satisfied by way of showing how it was created and how it has been fulfilled.
So in 14th November, they have found some not found in PDC register, the stocks was not correct. But in 27th, the stocks was correct.
Yes.
That is the report.
And the PDC register was found up to date, but 100% go down PDC report
Records on date 14/11/2023 was not found in PDC register.
My lord, may I take note of this query? I will come back with
yes.
Because as on date, my lord, I'm not sure. SQC I can understand this volumes, but PDC I will set.
Yeah.
But for the purpose of my submissions, my lord, my humble submission is that if an investigation on 27/11 says that the stock is correct, therefore any allegation of mismatch of stock 3 months prior to cannot be sustained, because the stock is a continuing action. And now, my lord, kindly also considers how I have explained with respect to the gap in stock, what are the documents which I have provided to the appellate. My lord, kindly comes to annexure P9 at page 149. Starting from page 149, page 151, these are the actual receipts. My lord remembers the ERVs. PRBs are essentially those receipts which are being returned back for effective cylinders
Okay.
or empty cylinders. I will just be pre-delivery checks.
Pre-delivery
Checks. Pre-delivery check is a register which needs to be updated. So that is
136, 137.
138 minor was written. This at the first paragraph. It was found up to date, but 100% go down. Pre-delivery check records on date was not found in PDC register.
Yes.
So it is about a check, pre-delivery check report which was not found. It has nothing to do with the entire stock.
Okay.
But still, my lord, I will
Okay.
clarify myself. Your lordship satisfaction. Now, my lord, kindly comes to at page 159. These are the original receipts with respect to the 11 missing cylinders.
149.
149 beginning and it ends at 150. I will kindly come to 151 first because these are the two receipts which was issued to the new customer. So this satisfies the two cylinders which are not found. And let me see that the installation slip, that is that when the gas connection is given, at that point of time, new cylinders are also handed over to the customers along with the installation slip. So once installation slips are issued, then necessarily a new gas cylinder has to be given along with the regulators.
Okay. This is the delivery of 14.2 kg Indian LPG cylinder.
Yes. Hello, we are all dealing with 14.2 as of now because there is no other weights are concerned with this. Acquisitions are all related to domestic cylinders. Now, my lord, we kindly come to page 149 first.
Yes.
Except on the slip which is appearing on the right hand side at top, my lord, we find there is a handwritten remark installed. This is with respect to installations, and the rest are all being returned. These are the slips for those.
Okay.
So, my lord, if I count the rest, these are all the 9 in numbers, all 14.2 cylinders. So, this explains how the cylinders have been kept in stock. And my lord, on the next page, at page 153, I need a photograph, my lord, with respect to the inspection which happened post appeal. The same inspection which has been referred to because they continue to have inspections and on a time to time basis. And what we have in mind, this is another inspection which is happening, but they have not made any aspersions with respect to the continuing default. My lord, another line of submission would be that if there had been any gap in my stock, the gap should have continued. So, admittedly, in the appellate authority order, they have made inspections, they have found that there are no gap in stocks. Post the original company. And P11 minor, where there has been an instance of inspection, which they have raised more objections. That also goes to show that till date minor has not been. There has been inspections, but there has been no adverse report against the leadership.
Yes.
Now, my lord, with respect to the third issue is minor, but still I will deal with it. That is with respect to detection of full number of underweight cylinders already delivered. My lord, why it is minor? The reason being that there is an obligation of the delivery man to weigh the cylinders and put it on the delivery vehicle. They have found that I have not weighed properly. My lord, my argument to that is that if your findings initiated, the recording of the officer is initiated, that usage of that initiated record cannot further the cause of any allegations, even as minor as the allegations of loading underweight cylinders in the delivery. Actual aspect, I have concluded. With respect to judgments, my lord, may I proceed? Because
Yes.
there are primary allegations, I have dealt with those allegations, my lord. Let me.
Weight of empty cylinder is 15.6 kg.
And it may not be, my lord. What happens is that any weight that is called tear weight.
Tear weight.
Tear weight is treated on the cylinder. It assumes that the structural weight of the cylinder, that is iron.
Yes.
Iron weight is treated by the pressure. Now, my lord, the gas is inserted by way of pressure and sealed by the cylinder. So, then the weight, the ideal weight of the gas is sold to the consumer should be 14.2. And law says that it is there is a allowance of 150. That is what legal methodology have demonstrated that as per the schedule Roman 8, there is an allowance of 150.
Yes.
But I'll be referring to Asha Sharma versus Chandigarh Administration and others. It is 2011 10 SCC. And I'll be referring to paragraph 12, 15, and 2. But, that's been accidentally marked.
Very well, thank you. No issue.
Premises. I found that the better copies are with my line city. So
Very well.
maybe it's not present in court. I found out one thing. And the premises that arbitration is state action.
Paragraph 12.
Whenever both the decision process and the decision taken are based on irrelevant facts while ignoring relevant consequences, such an action can be normally termed as arbitration. The respondent being a state cannot bother its action or inaction under contract when the retribution established that the action is per se arbitrary and existing to arbitrate are there has been an attempt by the respondent in the objection that it is a contractual obligation. There is no election. There is an existence of arbitration.
Yes.
So, to counter that matter, first, my lord, the regional corporation state arbitration, there is no argument to that. Second, my lord, with respect to proceedings also, the basis on which, my lord, the entire inquiry proceeding is both stage 1, stage 2, as well as the decision initiated by arbitrary constitution. Given the fact that as per law, under the document which has been created, the report which has been created, is absolutely initiated because it has not adhered to the prescribed guidelines of the Legal Diplomacy Act or the Injunction. So this is essentially the marriage of this particular proposition, that is the action which can be termed as arbitrary, and why this is an arbitrary action, and why therefore the report can adjudicate the issue, even at the expense of having an arbitration clause between the dealer and the dealer. And in the context of the present case, yes, and more so, my lord, in the context of the present case, my lord, I have already stated that the legal rules clearly prescribe that unless there is an allegation of tampering or unless there is an allegation that the dealer has done some mischief, there is no way a dealer can be penalized in any manner. Because NDG cannot overrule a guideline of the state. My lord, can we consider Indian Oil as the state?
Yes.
Indian Oil as a state cannot create a guideline which can overreach the statute.
Beyond the MDG.
Yes, yes. My lord has fully appreciated what I am trying to say. My lord, I will not repeat the issue that with respect to the looking of the weighment, the desired sensitivity of the weighment that has not been
Yes.
by the incident. Therefore, my lord, the last thing which the appellate authority has done, appellate authority has essentially not even applied its has almost in total added to what the original inquiry officer has passed in order. So that does not impart any color of legality to the order, because to consider the same, it has to consider the report. The reports are per se arbitrary. There is no way the appellate authority would have passed any order other than dismissing the entire inquiry, and hence the report should entertain this petition and pass necessary. code SCC 69. Look, kindly sees the head notes, man. Well, as grounds of judicial review, such dismissal cannot be set aside for absence of material to support the said ground. Such affirmatively, the dismissal order is not purified by mere affirmation. This is what I was referring to. That even by the repetition of the appellate authority of the order passed by the authority of the first instance, then my power of judgment. But I think primarily and it is paragraph 3, 5, 7, and 10. Relevant for this.
Paragraph 82.
Paragraph 82, particularly subparagraph 3, 5, 7, and 2.
Joshi Technology International.
Specific application of when report can intervene and when it will discuss.
Paragraph 82.
And 5, 6.7. At page 760.
7.
That it is not a statutory contract. So we are
No, 763 pages. Page is different, I think.
Okay. Admittedly, this is not a statutory contract.
No, this is MP Power. MP Power Management Company.
I am extremely sorry. Thank you. The mere fact that if it's sought under a contract which is not statutory, will not affect the respondent state that is by itself the board of scrutiny of its action or inaction under the contract. If the company party is able to establish that the action is per se arbitrary.
Yes.
After the contract is entered in, there can be a variety of by the contract with the state to seek relief via per filing of it. Then the existence of an alternative is undoubtedly a matter to be borne in mind by the reputation of contracting. Again, the question as to whether the reputation must be told of the dates would depend on the question which would have to be decided at most important. Resolution of which prelude to the grant of under 50 while there is even deciding that particularly around 65 of documents, the court may regulate the part of the under in this particular case, justice of facts. So there is no bar with respect to entertaining the written. But in the same point, the reach of Article 15 enables a writ to take the argument state action even after a contract is written by the state. A wide variety of circumstances can generate cause of action. The court's approach is still to be guided by the overwhelming need to arbitrary state action in cases where the writ provides a justice arising from palpably unreasonable action by the state. Dependability that is true, but that not said. Change the bench.
So what is the punishment awarded?
The punishment of 85,000. But the important part was
Where is the punishment?
My lord, kindly comes to page 144. The calculation of the punishment is at page 144. It starts and my lord, it culminates at page 146. It will be appropriate if my lord comes at page 146. It is a penal punishment of 1,90,564 already, my lord. 85,000 has been deducted from my business account. And there has been a stay by this court for recovery of the rest of it. The difficulty, my lord, is that if this, under this set of circumstances, if this punishment is allowed, the allegation of major penalty will stay, and that will have a compounding effect if at all I am found in default in the next section.
No. So where is the calculation?
The calculation is at page 140.
Okay. So how they calculate? There must have some procedure for calculating.
Yes, I am not questioning the manner of calculation, my lord, because it depends upon the number of cylinders which are missing and the accumulated sales which has happened, and they have a staggered way of calculating that based on sales, prospective sales which might have happened, and the cylinder which got lost.
It is in the MDG.
It is in the MDG. So I am not questioning that portion of calculation. I am questioning their findings and the manner of deciding the case. But the entire inquiry has been questioned. Let me, my lord, come back on the next day. Just 2-3 statements regarding my lord had asked me on that PPC and SQC. I will, if there is anything to elaborate, my lord, let me elaborate that, and then my lord, let my learned friends start there.
No, this is the order of appellate authority.
Yes.
Where is the first order?
Under kind comes to page 140, 130. Starts from page 106. The speaking order against shoppers.
Yes.
It culminates at page 100. My appeal, my lord, that is at page 110.
Very
The authority order starts from page 130.
What are the charges?
And volume of at page
83.
with respect to dealing with the it's part of the MDC. Fine. Starts from page 7. I minded the once average under established itself as a compound.
Because in the second time, if some difficulty, it would be, they would say the habitual defaulter is there. So major punishment will be. The first charge is the more than 25% of the filled LPG cylinders loaded in the delivery vehicle for delivery to the customers. This is the first. shortage of more than 50 domestic LPG cylinders or domestic pressure regulators are both put together detected during the inspection. Shortage of 50 domestic LPG cylinders. Third is unaccounted sale for more than 50 feed LP cylinders. Non-compliance of
Essentially, we boil down to the three aspects which for that.
mainly first three charges. Underweight service supply of cylinders.
Charges, and the other would have a calculator. There are two charges on grounds of weight, and one is with respect to accounts.
Shortage of 50 domestic.
Related to weights, one major and one minor, and
Area. So whether you have concluded today or
this will be very much. I will just put in these statements. So my letter starts with
otherwise you can address those points at the time of reply.
I have prepared the written notes, but I intend to also address what my letter is stating.
Yes.
That would be easier.
That will be better for submission of written notes.
My lord, regarding the supplementary affidavit which my learned friend is relying on, my lord, a copy has not been served.
You hand over a copy.
My lord, we have to see whether we are going to deal with it or not. There was no brief for this actually, because the pleadings were completed.
Only the order of the appellate authority missing one page.
Oh. I have not seen that, my lord.
Only see he just tagged the page, not more.
A copy may be handed over to us.
Yes, he handed over copy. এটা দিয়ে দিন। উনিশ তারিখ হবে কিনা ঠিক নেই। 23rd 19 তারিখ যেটা করলাম ওটা যদি 19 তারিখ না আসতে পারি, সম্ভবত আসতে নাও পারি, না আসতে পারি তাহলে 23 তারিখে ফিক্স করে বলে দিলাম, মনে থাকে যান। ঠিক আছে, 23 তারিখ সেকেন্ড হাফে 3টের সময় ফিক্স করবো ওটা। এখন কিছু বললাম, হ্যাঁ 23 তারিখ 3টের সময়। ঠিক আছে, আর 2 তারিখ থেকে 16 তারিখ পর্যন্ত পুরো আমার সেকেন্ড ডিভিশন ম্যাচ চলবে। তাহলে আমি কি করে বসবো? একদম জানুয়ারি 2nd, না জানুয়ারি 3rd 2 PM, January 3rd 2 PM, right? January 3rd. Please take down.
আমি আজকে মেল করব।
Petitioner intends to file one supplementary affidavit coupled with a complete copy of order of the appellate authority. He submits that the copy of order of appellate authority was placed on record, but one page is missing there. So he intends to place the supplementary affidavit. Let the supplementary affidavit be kept on the record. Copy of supplementary affidavit be handed over to the learned counsel for the respondent. Copy of the supplementary affidavit be handed over to the learned counsel for the respondent within course of the day.
Right.
Argument on behalf of the appellant heard in part. Let the matter appear in the list on 3rd of February at 2 p.m. 3rd of January 2025 at 2 p.m.
I would have handed over a copy.
Okay. Yes. Okay.